Possession of a residential home, my lord.
May please your lordship, I would like to mention the case titled as Likhma Singh through LRs versus Financial Commission.
After notice.
Your lordship, this is a civil appeal which we have. Your lordship, the eviction notice has been passed, and the petitioner are directed to evict that particular land by 22nd itself.
By whom?
By financial. Actually, this is a High Court order which has been passed.
Is it a fresh matter?
Yes, your lordship.
Fresh matter.
Yes, your lordship.
All right. Then
And-
is it a civil appeal?
Your lordship, this in this matter, the petitioner was directed to eject that particular land. Actually, this land. Yes, your lordship.
देख लो भाई क्या है.
Your lordship, one more request. Your
Get
lord-
on with it. We'll list it. Yes. Mr. Shantanar.
Well, there's a single judge order of the Patna High Court, which has said that there has been wrongdoings in the Bihar Cricket Association with the
Fresh
official
matter.
selection. It's a fresh matter.
Don't be listed.
The first match is on 26th. Now the
Alright,
selection
it-
committee
it
has
will
been
be
thrown overboard
Yes.
with some early date.
My lord, this pertains to my life and liberty. I was
Fresh.
Yes, I've circulated a letter yesterday. I have.
Will be listed. Don't worry. You don't
My lord, I have to
Yes.
surrender before the court.
I am
My lord.
mentioning,
Will be listed. Don't worry.
I'm so grateful.
I am
If the-
mentioning IA in a common cause matter. We filed in February. It shows in case it's different time. It's now on 4th November. It is showing on 4th November
It's
now.
already on board on 4th of November.
Let it not be deleted, my lord.
Yes.
My lord, this is a challenge to Rajasthan Judicial Service matter. My lord, it is listed
on
at
board today.
Plus 9 more students have approached before your lordship. I have circulated it later, my lords. It might not reach today, my lord.
Look, we have got about 7 trunks. We had asked for the English essay examination to be, the papers to be produced of all candidates who got less than 15 marks.
Yes, my lord.
7 trunks have come here. When the matter is called out, we'll examine it. You be there when the matter is called out.
Please, your lordship, this is a one more
Already
request.
passed.
Your lordship, the stay shall be granted till the
This possession
matter,
of
your
residential
lordship.
Call out, call out.
Your
Lordship's time ended, now we have gone. Item 1.
Statutory appeal.
Petitioner.
I do.
Mr. Ramadi, purely a factual question, and these are all rooftop solar installations.
With respect, my lords.
And the High Court has said that the 180-day commissioning period should begin from 3rd of May
So that's
2016.
correct, Manoj, because the PPA is categorically signed. If your lordship sees the date of the PPA,
It's a possible view, Mr.
Manoj, with respect, there's a divergence of views firstly. The KERC held in my favor.
I know, but
Your lordships have already issued notice in a similar matter, Manoj, where the same issue arises. That batch of matters, Manoj, I'll just pass on the order in a civil appeal. Now,
that was slightly different, wasn't it? Or is it an identical point?
no, one of the points is identical. One of the questions which arises is when does the period of 180 days run?
Actual has clearly found that the commission specifically in this case, para 9, approved my PPA after they had passed the second generic tariff order, which curtailed the first generic
But-
tariff order.
but
And
that-
The modified PPA was approved on 3rd of May
that's
2016.
a day after, para 9. So therefore, my lord, even after
The tariff order was 2nd of May.
That's right. So even after curtailing the tariff from 9 rupees to 520, they approved my PPA, which had a 956 tariff.
That's
So
correct.
that's what the appeal found.
But
Number one.
that is why, Manoj, we made a mistake. Just let me just place my point, Manoj. If your lordship sees, yes,
I think very important, Mr. Ahmadi, is
yes, Manoj.
that you paid at the rate of 9.56 rupees per unit until 1st of January
That's
2017.
correct, Manoj.
So once you
That
paid him,
we made a mistake, Manoj, because, Manoj, just let me.
so why should we not give the benefit
No,
to a citizen?
No, with respect, because Manoj, he is otherwise getting a windfall. The tariffs are fixed, Manoj, depending actually,
Why did you pay him until 1st?
because we made a mistake, Manoj. Now,
Now continue the mistake insofar as he's concerned. Why should we
May I-
ultimately, look, some fairness to a citizen also has to be.
so now just let me place the point. Manoj.
Previous tariff is not out of the hat.
Let me,
It's based on the
let me
generic
just place
tariff
the
order of
point,
the
Manoj. I won't take more than 1 minute.
Yeah.
Let me place the point, if your lordship permits. Now, Manoj, the guidelines make it clear. The guidelines are 7/11/2014. If your lordship sees page 88, the guidelines make it clear that the commissioning must be within a period of, Manoj, 180 days. Now, kindly see the facts of this case. The first PPA with him, Manoj, is 31/1/2015,
You're right.
which is only, Manoj, for 50 kVA. Your lordship gets that? For
That is
500.
for 500 kW.
Correct. Now, we give him the first extension on 5/7/2015.
Gave him multiple extensions.
Multiple extensions. Now, my lords, finally, the PPA is inked with the enhanced extension for 1,000, my lords, on 5/1/2016 for the enhanced capacity. That's page 20. It's my case, my lords, that the period of 180 days will run from the date of the PPA. That's my case on law.
But the modified PPA
Yes.
was approved on 3rd of May 2000.
But before that, he had not understood that to say that I can't do any work. On 4/4/2016, there is a report that he continued with the installation even in the meanwhile, page 126. After that, my lords, now just see the express terms of, my lords, the modified tariff order. If your lordship will be pleased
What does
to
it
see,
say?
page 135.
What does it say?
It expressly says, my lords, that so far as new PPAs which have not been commissioned up to the date of the tariff order and which are to be commissioned in future, those PPAs will
But
get,
see, his PPA was in January,
that's correct.
though it was approved on May. Therefore, once the approval comes, it relates back to January.
No, with respect, my lords.
That's the point.
With
there.
respect, just see the terms, my lords. Just see the terms of the tariff order at page 100 and just see one page, my lords.
What is the total quantum?
2 lakhs a month.
No, my lords. It comes to approximately the overall financial liability is 13 crores. And it's only not limited to this case,
years.
because what happens is,
See, the thing
because
is
they
that
are getting,
on the one hand, we say rooftop solar.
because they are
People do
getting,
this in
let
high
me
street.
explain. They are getting a windfall for this reason.
Somebody makes a windfall. That's what business is all about. But question is whether we should interfere merely because he's getting some financial.
The question of law that arises is just see, my lords, the express terms. Just see the express terms, my lords,
Thank you,
at page.
Mr. Ahmadi. We've crossed the 1 minute. Thank you.
As your lordship, please.
Lord, the moot question here, my Lord, was striking at the root of arbitration law, my Lord. Whether, my Lord, they're in an admitted situation where, my Lord, even prior to commencement of arbitration,
Arbitral award. 34,
I admitted the
34
liability.
34 dismissed and 37 dismissed.
my Lord, all along, the problem is that all the three forum, my Lord, did not address this issue.
Something has to.
For
rest
different
now.
purposes, my Lord.
There's an arbitral award.
With
but
greatest
after
respect,
the
yes.
34 has been dismissed,
Yes,
the
yes.
37.
But, my Lord, Lordship will see that neither of the forum below address this issue. And, my Lord, it is very fundamental. Lordship have already taken a view.
And
that when there is
your only contention is that because your payments from BSNL were held up,
Not that-
therefore you will not pay him,
My
therefore
Lord,
you are
I did
delayed.
not
How is
say-
it concerned?
My Lord, kindly see, with greatest respect. What I said was, my Lord, may I only say this?
Yes.
My Lord, my contention was not that my liability is dependent on
Your-
payment.
Your contention really is that
Yes.
because the payment which is due to him is admitted by you,
By me.
therefore there is no dispute.
There is no dispute.
But what is it, Brother Manoj Mishra just mentioned, the words used are breach. Now, breach is wide enough to comprehend even non-payment of an actionable claim.
My Lord, it is like, but
would it not
when
be
we,
very technical
Lord-
for your, look at your client's contention. You said, look, I have admitted my liability towards him and therefore there is no arbitrable dispute, you say.
yes.
How can that?
My Lord, may I only answer it like
On
this?
this point,
May
look,
I only
on
answer?
this point,
May I only
you are
answer?
under 136.
Yes.
On this point,
Yes, my Lord.
three forums are against you. We are in a situation where there's an admission of liability by you to him. You say, because I admitted my liability, therefore there is no dispute. Can this be?
My Lord, may I only make two submissions? My Lord, may I make only two
Also
submissions?
for justice.
My Lord, may I make only two submissions? One is,
And even on law,
Yes.
you're not right because the word which is used is breach. Breach of an admitted liability would always also give rise to a dispute within
but
the meaning of.
with respect, my Lord, if we look at Section 7 of the Arbitration Act, it says there has to be a dispute. I am saying I have to pay. And I have given much prior to commencement of arbitration, my Lord, I have given a schedule.
We can't take such a narrow view which will defeat the purpose of the Arbitration Act.
And then, my Lord, there is a contradiction also in the award itself.
Thank you.
May I just say, Malas, one thing for my
See,
satisfaction? Gratefulness.
Lord, Lordship has already taken a view on this.
not at all.
There is a judgment which is not even adverted to by the Honorables.
Thank you. Item 3.
Lord, here the
Yes, Mr. Mehta.
My Lord, here the question is, my Lord, whether the state government, with regard to its sales tax
issue notice here, because question is whether sales tax dues of the state government will rank over the IBC.
Correct.
You are for the government.
Yes, my lord.
And you're saying that you are relying on rainbow.
I am relying,
There's a rainbow is up for consideration before a larger bench, I think.
lordship,
Anyway, we'll issue notice. It's a question relating to issue notice.
obliged.
No, sir, we'll not entertain this. Thank you. You're saying that, that you're challenging, you're saying that the term Hindutva should be replaced with the phrase Bharatiya Samvidhanatva or Indian Constitution.
Sir, please grant me just 2 minutes to make my submissions.
No, sir.
Just 1 minute, sir.
This is a complete abuse of the process. Dismissed, yes. Item 5.
It's a fresh matter. I am praying for some time to file documents to prove two things, my lord. One, that the consignment booked was admittedly overloaded.
One, what you are saying that in ground A, you have said that the judgment of the High Court is per incurium in view of their own judgment in Union of India versus Meghalaya. Are you pressing that ground or no?
My lord, that also because at page 103, the Honorable High Court by coordinate bench has held that the notification of 50 stations is not confined for charging
How much is the
terminal
total amount involved in this case?
My lord, 1,56 lakh odd, my lord. And I also need to place on record circulars which say that 50.
The High Court says that after you cannot charge punitive charges after unloading of the goods at the destination.
Not for that purpose, I have documents to show that the consignment book was overloaded. That would go a long way to charge overloading charges.
You should not have permitted to upload the goods in the first place. Why did you permit it?
That was wrong, my lord.
That's all finished.
But not overloading charges, if he has booked.
5 and 30, therefore, we'll dismiss. 30 is the same, no?
Yes, my lord, same.
5 and 30 will dismiss, yes. Yes, Makija, the property, the hotel premises are in Ahmedabad. Parties are from Ahmedabad. It says that the place of arbitration shall be New Delhi, and they have appointed a sole arbitrator.
That's immaterial, Your Lordships, because
The juridical seat will be Ahmedabad, actually.
it won't be, Your Lordships. That's completely immaterial. Once there's a party autonomy, once there is a clause of place of arbitration, after BGS and BBR, Your Lordships.
What difference does it make whether the
It makes a
arbitrator is
difference
appointed by the
because
Delhi
the
High Court
whole
or-
law, which was clarified in BGS SOMA, will be upset.
You entered into a sublease for a
Lordships,
hotel premises situated in Ahmedabad.
Lordships will kindly see my arbitration clause. Give the chart, no? Lordships may kindly see this. This is a conflict legal position.
14.3 expressly uses the word place.
I'll just explain to your lordships what the law is and relegated to a law which was prior to BGS SOMA. Lordships may kindly take this chart. This is the conflict of views, and these are all the views which have been held and concurrently held and followed after BGS SOMA consistently.
Say about clause 16.6.
I'll explain that because BGS SOMA very clearly clarifies that if there are two clauses.
Consequence arising therefrom shall be governed by the laws of
Absolutely.
India.
So that is.
And shall be under the jurisdiction of the courts at Ahmedabad.
That is exactly what is explained by Justice Nariman in BGS SOMA. He says that there are two clauses, two sections. One is section 20, subsection 3, and there is a section 2, which defines court. These are for two separate purposes. As far as venue and seat is concerned, it is connected to party autonomy. And the arbitration and challenges to arbitration, the appointment of arbitrator will all be relatable to the place which is equivalent to the seat. Now, this is the view which has prevailed now. And prior to this view was that if there are two jurisdictions, that was the Balco view, that if there are two jurisdictions, then either can be invoked. This honorable court has said.
Been looked at also by the.
No, it cannot, your lordships. Let me
ultimately,
Lordships will give me 2 minutes. Lordships will see
but
what lordships have held.
we have to always make business sense out of any contract.
Business sense
Now,
only, Your
parties
Lordship.
are based in Ahmedabad.
Business
The
sense
sale
only.
is based in Ahmedabad. And third, clause 16.6 specifically refers
It's the
to the
jurisdiction
court.
clause. It's not the arbitration. And let me just show to your Lordships.
This place as a
Lordships, this will create havoc, and if your Lordships will just
Nothing will
give me the indulgence of taking this chart.
And you're going to have an
Consistent.
arbitrator appointed who's a former district judge.
Your Lordships, that's besides the point. The point is this, that
You
I am a
delay
national.
the proceeding, that's
No,
all.
I don't want to delay. Your Lordships will appoint an arbitrator. Today, I will go to the arbitrator. I do not have a quarrel with application, appointment. In fact, I want an arbitration. I have consented.
An arbitrator. You're not saying that that arbitrator is biased or something like that.
An exercise of jurisdiction, which is contrary to the law,
No, miss.
itself goes to,
We will-
Lordships will give me 2
Thank you.
seconds.
No, we'll not take it.
Lordships-
Item 7. No, Miss.
Lordships will just look
No,
at
not at all. We
para
also
82.
will have to look at the justice of the situation.
Lordships will kindly see.
Merely because a point of law is made, we don't issue notice.
It's not a question of law. I'll tell
Thank you. Thank you. Thank you.
Just give me a minute, your Lordships. The reason why I'm pressing is
Not-
for a particular
not a-
reason,
not a-
not to concern with my
Thank you.
parties.
Item 7, yes.
Your Lordships will then clarify.
Item 7 will issue notice on delay and tag it with that other matter. Which
Your Lordships, may I just clarify,
thank you.
seek
That is
for
over.
clarification,
No,
because
thank you.
now
Item 8.
I approached the High Court.
On the other side.
I don't think, my lord.
In the Bombay High Court, we had a very distinguished judge, Justice Dhanuka, who used to say, operation successful, patient dead. You went only for an order for expediting the hearing before the DRT. The High Court in your petition sets aside the orders in your favor, which were never questioned by the other side.
A blind man goes to the.
You know what? I read your petition twice over because I couldn't believe what I saw. I said, maybe I've read it wrong. So I read it a second time because it was we'll issue notice here.
Please, my lord. Please.
And serve Dusty and come
That's the
set aside
order.
this order and send it back.
Oblige, lord. Yeah.
Stay the order, by the way. We'll stay the order. Impugned order shall stay. Stay. The grievance of the petitioner is that in a petition which was filed by the petitioner under Article 227 of the Constitution for expediting the hearing before the Debt Recovery Tribunal, the High Court has virtually concluded the issue on merits that would have arisen before the DRT, though the orders which were set aside were not impugned, were not questioned by the respondent. Issue notice and stay.
Eight. 9 mine. 9.
Now, the notifications of 3rd of November and 15th March are in question before the NGT, the High Court has recorded.
Yes, my lord. That is a question before the NGT. But here, in the same matter,
Issue notice here.
the same interim order may be granted, that is on page.
We'll say notice on interim relief, serve them thus the income. Yes, item.
They have already operated the mines also, my lord. They have stopped. And even single day they cannot operate the mines, my lord, because they have.
So we are issuing notice, serve them thus the income. We are issuing notice on interim relief.
An interim relief may be granted for.
We're just saying notice on interim relief. You have to hear the other side, that's all.
This is Honorable Court.
Ms. Jaising, what is the interim relief that you are seeking?
My lord, the interim relief application is there on the record.
Just tell us, are you
The operation of the letters of,
dated 7th June 2024?
yes, my lord, because
Then,
all.
no, just tell us, because for our order we need that. 7th June of the NCPCR.
Be acted upon, my lord, because they are being acted
Just
upon.
give us the dates for our order.
So it is 7/6 and 25/6. Prayer number A at page 69.
Issue notice returnable in 4 weeks. Pending further orders, the letters, the communications dated 27 June 2024, issued by the National Commission for the Protection of Child Rights. 7 June and 25th June, right?
Yes.
Both by the NCPCR.
Yes, my lord, those 2 dates.
And what about the communications of 26 June of the Chief Secretary?
Consequent upon those 2 letters. So
And all-
obviously all consequent.
And all consequential steps taken.
B, C, D, E give you
Aisa kar lo.
the letters.
Pending further orders, the letters, the communications dated to 7 June 2024 and 25 June 2024 of the National Commission for Protection of Child Rights and the consequential communications dated 26 June 2024 of the Chief Secretary of the State of Uttar Pradesh and the communication dated 10 July 2024 issued by the Secretary, Department of Education and Literacy, Ministry of Education, Government of India, and 28 August 2024 issued by the Directorate of Elementary Education, Government of Tripura, shall not be acted upon.
My lord, then I have a small request to make, my lord. Obviously, the directions dated 10/7/24. I have made only Uttar Pradesh and Tripura parties because they're the ones who have now issued circular. Your lordship will be pleased on my oral application, allow me to add all states because all states are going to be
On
doing
the
the same.
oral request of Ms. Indira Jaising, then Senior Counsel, liberty granted to implead all states stroke duties. With notice issue.
Leave to amend.
Yes,
And
leave
these
to amend.
directions will
Then
apply
which
to
will be
all
carried out
states,
within the course of the week. And then you can say pending further orders, the order ho gaya. And you can save liberty to serve the standing counsel appearing on behalf of the states stroke duties and the central agency for the Union of India.
Deeply obliged.
My lords, the in item 41 is the recognized madrasa matter. Listed today. It's listed today. The recognized madrasa matters is also listed today. So
That's not my.
That's
your
it.
position.
Yeah,
My lord,
it's
I'm
fine.
appearing in item 4.
Yeah, it's fine. My lords, 41, my lords, today is the recognized madrasa matter in which this is the matter pertaining to all recognized madrasas.
That will deal with Bennett region.
Yes, so pleadings are complete in
Yes,
this, my lord.
item 11.
Your lordships will hear that.
I think 11 what should we consider, Milord. This is a case where Milord, the funds are collected from the consumers, invested by the state.
Yeah.
Lord, I appear for
Or
the
the
contesting
interlocutory.
respondent, my lord. Lord, the PDF rule itself says it has to be by way of investment by equity. Kindly,
You file your response. We'd like to consider this.
Lord, then
Notice, sorry.
an early date returnable.
Yes, yes, after 3 weeks, you file after Diwali. You file your counter, we'd like to hear you for maybe half an hour, we'll hear you for 15 minutes and then decide.
Lordship.
Deeply.
Notice also on the interlocutory.
Sorry?
In the IA also. Milord?
Yes, yes, we'll
Lordship.
hear
Okay.
them. We are not passing any order, you file your counter.
Lordship, please.
Deeply obliged.
Item 12, this has to be tagged, right? With
Quite so, my lord,
RBI
quite so.
versus
Quite so.
issue notice and tag.
Well, it's just one small request. I appear on behalf of DBS Bank in the previous matter, which was tagged on the 30th of September. The order by inadvertently record
My lords, my appearance had come in place of DBS. I'm appearing for RBI.
That's the
Different
only
respondent.
small.
Can you just do this? Can you come in the morning tomorrow or just at 1 o'clock? All dikha do. We'll just do it. We'll take it as a mentioning and correct the. It's only the appearances.
Only
right?
the appearance.
Only the appearance.
In the text of the order, my lords.
Also, my appearance for RBI has been given for DBS, so there's been.
What is the clarification that we have to issue notice?
That's para 4. Mr. Raghav Shankar appears on behalf of RBI.
But Mr. Navneet will accept notice on behalf of RBI.
The court
will
issue a revised
We'll hand it over in writing.
Would your lordships kindly consider condoning delay also?
Well, as in 12.1.
12.1.
Mr. Nankumar is appearing in.
How much is the delay?
54 days, 57 days, I sent.
Yes, yes, you can do it.
My lords, it's for hybrid mode of hearing by the family courts to get over the financial and logistic
Are governed by the provisions of the state courts. The family courts are not standalone courts.
My lord, they have been appointed by the state government, my lords. They are appointed by the state government under the Family Courts Act 1984. Therefore, they act independently, and it is not. They don't come under the High Court that way.
Notice, Mr. Jain.
Oblige, my lords. My lord, returnable.
Yes. Item 14.
In a review petition, and without even noticing the relevant regulations, relying on some regulation which has general application, but there is a special regulation, page 356, in regard to DVC.
Can you just sort of explain to us, maybe in a nutshell, what is the issue really? Because I was also wondering how in a review petition they did all this.
Depreciation has to be allowed anyway,
Right.
and there is a sinking fund in regard to DVC because of the historical
What Apple seems to be suggesting is that since the bonds which are issued by DVC, your client,
yes,
from time to time, are redeemed from the sinking fund, which is created under section 40.
Factually incorrect as found by the original judgment. In the review, without even any consideration, it's allowed. And please see the relevant regulation.
The sinking fund is not created by you from the tariff realized from the consumers?
No.
How is the sinking fund created then?
356.
Because at page 24,
Yes.
the tribunal holds that
Yes.
since it is created under section 40 from the tariff which is realized from the consumer, therefore the capital asset created through such bond amount does not qualify for depreciation as a pass-through tariff element. That's
In
the
original judgment, this aspect is considered and said that these are not the funds which are used for the purpose of creating the capital asset.
In 2018.
Yeah.
That both recoveries.
And they
Just make us stand 33 and 34 of this imprint order. Just make us understand
Yeah. Now, please see first.
it first.
Yes.
And just make us understand what is the
Let the reasoning of the tribunal is in the review petition. The earlier judgment of the Supreme Court did not go into the duplication.
It says, it cannot be gainsaid that redemption of bonds
Yes.
from contribution
Yes.
to sinking fund
Yes.
is a special tariff element provided to DVC
Yes.
under section 40 of the DVC Act.
Yes.
So something to do with interpretation of this provision.
Yes.
In addition to the tariff elements provided in the tariff regulations issued by the Central Commission from time to time, there is nothing in the above noted judgments of this tribunal and of the Supreme Court that depreciation shall be allowed on the capital assets created by utilizing the bond amounts. What is it trying to convey?
Now, the question, this specific question is raised in the earlier round at page, kindly have a look at page 155, 156, para 25 of the tribunal.
What the tribunal seems to be saying is that a distinction needs to be created between depreciable assets created by the use of the bond fund and depreciable assets created by the use of funds from other sources. If you accept that.
Can I just add, Lordship, permit me? What happened, Lord, when this DVC was initially set up, the government didn't want to fund it from its own money.
Right.
So the government decided that there'll be a sinking fund for the original capital asset, not depreciation comes much later. Your Lordship knows. So the original capital asset was set up on the basis of which fund, and section 40 of the DVC Act said that this fund will be, the servicing of this fund will be by the tariff. So that was the original asset when it was created. Depreciation under the regulation, your lordship knows, is for the use of the asset and its replacement value whenever it will happen, maybe 15 or 20 years later. So depreciation has been separately provided for by the Act, again by the Act, DVC Act itself. So sinking fund, the original creation of the asset, and depreciation for the replacement value of the asset whenever it will have to be replaced. That is, replacement is not done by the fund. Replacement is done on the basis of the depreciation only. And replacement has not even happened today. Replacement will happen at some stage because these are all funds which was taken between 70.
And the tribunal now in review holds that you will not be entitled to depreciation on the sinking fund.
Correct, on the sinking fund.
Because originally when it was created, it was out of the tariff.
And Miller, kindly see the relevant regulation.
What are you saying? You're just
this court, this issue actually came right up to here. 2007, Lord Justice Anil Dev Singh, when he was sitting Lord in the appellate tribunal, said that they are entitled to both the sinking fund also as well as the depreciation. One private party came here and Justice Gogoi's judgment in 18 said that yes, these are both statutory entitlements of the DVC and they are not
irrespective of the source through which the sinking fund arises.
That's right.
Namely, this a tariff pass-through element.
That's right.
Because it is really a depreciable asset. The sinking fund itself,
depreciation is provided for in the regulation.
All right, what we'll do is we'll hear the other side. Maybe
Lord,
we'll see.
Will have to be granted. Otherwise, Lord, the whole my whole accounts will be going for a toss.
But the orders of what we'll do is we'll issue notice on interim leave.
But
keep it after 2 weeks.
These orders have been in existence from 2004.
We'll keep it right after Diwali. What we'll do is we'll keep it.
Will start, Lord, the whole thing will start.
We'll keep it right after Diwali, serve the other side and come.
Very well. But let's status quo.
We'll keep it right after Diwali. Let's issue notice on interim relief and hear them. Yes, serve them dusty. Item 15.
Yes, my lord. Your lordship, I am
The
corporation.
main matter is pending here. This is an execution.
The execution is disposed of. The 34 is pending. They moved a stay till date. 5 years have passed. No stay has been granted by the 34 court in a 36 too. So my learned friend just says the 36 court said that at the moment there is no reason why the execution should not be allowed in the matter. And that's all, and it's all subject to the outcome of the 30.
I think this Tata Motors versus DTC has come to us so many times, I think. Previously, we have dealt with this. There's a dispute on different phases. May not be in this case itself, but... And ultimately, it's Tata Motors. You'll get your money back. Where are they going to run away if they get it?
The order says so. The order says it is subject to the outcome of 34. Even the earlier amount released is against bank guarantees. And this also the court says is subject to outcome of 34.
Court says, right or wrong, I have to execute the award.
Right. There's no stay.
The statute says so. The statute.
It's an executable decree now.
Unless it is stayed, it shall be executed is what the statute says. That's the mandate of the statute.
See, these are not fly-by-night operators, that your money will be gone forever.
Raise this interest on which the statute itself provides.
Your lordship will have...
You notice that's the only point really.
Yes, so on that, my lords, they fall into the error of relying on D Khosla.
Their argument was that from subparagraphs D, E, F, H, I, and K, interest should be excluded from the 18% award. But the award doesn't say that.
Not only that, the statute says, if your lordships were to see the provision specifically provides under both the categories, the provision is 31(7) A and B if they are to be seen. Categorically say interest from the date of the cause of action till the date of the award, and 31(7) B says that post-award interest on that entire amount can be granted. Now, D. Khosla was a case under the 1940 Act where this interest was not provided for. So the Supreme Court in that judgment said that unless there's a statutory scheme, the decree holder can't ask for interest on interest. That was the case. So that is why the executing court rightly says you are citing a D. Khosla judgment, citing a line out of context to say no interest on interest. That very paragraph says that if there is a statutory scheme,
it's an order passed. It's an order passed from execution. Why should we interfere?
Your lordship will appreciate our principal amount is 296 crores. We have already deposited 340 crores. Your Lordship will appreciate on only 100 or 120 crores is left. My Lord will appreciate 23 times my stay application has been
That's
listed.
why arbitration must have some sanctity. Why should we today interfere?
In fact, every matter, this is what
Needed.
happens.
And ultimately, whatever you pay will abide by the final result of the 34 which is pending.
And
Your Lordship
says so.
Your Lordship will accommodate me till 29th November. It is listed for final disposal on 29th
All right,
November,
but you
section
pay.
34.
That's all right. That who knows whether it will be listed on 29th of November, heard on 29th November.
My Lord, may kindly pass a direction in this regard. My Lord, 29th November, it will be over.
It's a money decree. There's no stay. Let them have the benefit of that. And if you succeed, you'll get the money from them.
My Lord, heavens are not going to fall when we have already deposited this much.
It's a money decree in their favor.
A profit-making venture,
So
my Lord.
what? But for them, it's a profit-making venture, and we must therefore have respect for the fact that you deal with entities which are in it for the business. They are investing money.
It's a 2017 award. For 7 years, you withheld that money.
All right, sir. Dismissed.
Grateful, my lords. Very grateful.
Lordship is this.
16?
But I appear, my Lord.
Why should we interfere at this stage? You have an appeal.
No, but kindly see, kindly give me 2 minutes. Earlier,
order of assessment, which you can always challenge in appeal, Mr.
My Lord, but this is during the Corona period. I have not been able to give answer because I was given 2 days notice. All high courts across the country have taken a view. Giving 2 days notice is not enough. Sir, earlier 3-4 notices I replied. At the time when the last notice is received, my chartered accountant is hospitalized. He has a bypass surgery. He is in hospital.
They're all, it's an order of assessment under the Income Tax Act. You have a remedy of an appeal before the CIT appeals, then the ITAT, then the High Court. You want to sort of just completely make a short circuit by filing a petition under 226. Against the order on merits, and you say natural justice, argue it in the appeal. Tell her, dismissed, yes.
High Court has, every honorable High Court has interfered.
Will not interfere. Item 17.
Because in item 17, the parties at the time of entering into the contract quantify damages at double the amount. So from 3 lakhs, it becomes 6 lakhs.
If you have succeeded
in part. He has reduced it from
17 lakh 95,000
1795 down to 11 lakhs 51,000.
Mr. Diwan,
yes.
5,700 square feet at Rampart Row.
Yes, so there your lordships have seen. No, but your lordship saw the findings of the High Court itself, saying that, look, there is no access to this particular road. There's a small gully over there, etc. And the building is not in mint condition. That's the expression used. I am just making a suggestion. When the 2 points, well, I have only 2 points. Point number 1 is that the agreement itself said that if you stay beyond the period, because I'm asserting that I am a statutory tenant, is double. Now, the double amount is 3 lakhs is quantified in the leave and license agreement, double becomes 6 lakhs. 6 lakhs is what has been provided till the date of the decree. Now, the question is only
post-decree.
Post-decree. That's all we're concerned with.
Been asked for 6 lakhs to pay
11 lakhs 51,000.
The date of the decree?
Yeah. The date of the decree itself is 17 December 2022. 17 December.
From 18 December 22, you'll have to start paying at the later.
Yes. So, Manoj, I have only 2 points. One is 6 lakhs may be maintained. That's my first point. The second point is, and we've set this out, Manoj, in our synopsis, the measure used by the Bombay High Court is 6% of the ready reckoner rate. That ready reckoner rate, I've quantified it, Manoj. I've put it in the list of dates. Please see page O and P.
So, Diwan, what is there in 136 for us?
6 lakhs, Manoj. It should be maintained at 6 lakhs is our request.
Leave it, Mr. Thank you.
Very well, grateful.
Item 18.
Manoj, would your lordships just... Would your lordship just extend the period by 3 weeks for arrears from today?
Time for payment
of arrears.
We do not find any error in the. There's no error in the impugned order of the single judge of the High Court of Judicature at Bombay, dated 27 September 2024. Full stop. The special petition is dismissed. However, time for payment of arrears is extended
3 weeks from today.
By a period of 3 weeks from the date of this order.
Yeah, please, grateful.
Item 18.
This is regarding non-adversarial litigation regarding e-copying. It is permissible for for third parties through physical filing, Lords, but not through virtual Lords.
It has to be, what's your earlier petition, writ petition, criminal 552, that's on a separate point, right?
552 Lords, it's my petition where I am the petitioner Lords, which they say I am eligible to file through e-copying Lords.
E-copying facilities to be made.
But if I file for some other matter where I want to implead or Lords intervene, if it's a pending matter I want to
Notice, yes. We'll issue notice.
much of legends. May I say almost one small out of time request because at the mentioning stage I was cut off Lords. Lordship may consider life-saving treatment for a child.
May it please, Lordship. The predicate offense goes. If your Lordship kindly sees page 111, the ECIR is registered on the basis of the predicate offense, which is FIR 163 of 2018. In that, a closure report is filed in 2019, accepted by the magistrate on 18th of April 2022, has attained finality.
You didn't challenge it?
Nobody has challenged it.
You are the first
No,
informed.
163 of 2018, I was the FIR informant. Then what happened was, based on the further investigation, the auditor of that local cooperative service bank got 3 more FIRs registered, in which one of the FIR is against me. I am the original FIR informant. And what ED does is, after the predicate offense, which admittedly in their EC, so it's an entire role reversal from being the FIR informant. I've now been roped into this entire allegation.
Stay for a moment before we continue hearing him.
Yes, Your Lordship. Lordships, the judgment of Your Lordships in Vijay Madan Lal Chaudhary, it considers 3 points, Your Lordships. One, that is if the person is discharged in the predicate offense. Second is the acquittal. And third is quashing. In this particular scenario, none of these 3 are applicable because there is a C summary which has turned in this particular case. Now, that aspect was not considered in Vijay Madan Lal Chaudhary. Therefore, the High Court says when 3 of these are not to be taken into consideration for this particular case, then we have to differ from the judgment of Vijay Madan Lal Chaudhary. Vijay Madan Lal Chaudhary also considers only 1 FIR. Now, here what has happened is there was predicate offense of 1 FIR in 2018. After that, before this particular FIR turned into C summary, 3 more FIRs were filed by the statutory authority, that is the registrar. Now, the ED says that these 3 FIRs have been subsumed in the original FIR of 168 of 2018. So therefore, there are 4 FIRs at this point of time. Now, even if the 1 goes, 3 remains. So therefore, the ED can continue with the investigation.
How are these 3 FIRs subsumed in the first FIR?
Because when the first FIR of 168, they started with the investigation. Now, during the investigation, there are number of FIRs which have been filed. This is with respect to that Seva Vikas Bank, Your Lordships will have already considered.
Are you supporting him?
No, Your Lordships, I'm not supporting. I'm saying I'm the victim. I'm the complainant, original complainant.
The complaint.
Yes,
I'm not for the complaint.
I'm also the FIR info. The original, the predicate offense, which was based on the FIR, is based on my complaint. He is on a subsequent complaint.
Now, who lodged the first FIR?
I lodged it.
He
and then there was 3 subsequent FIRs.
Subsequent FIRs.
In which you are the complainant.
No, my complaint is the different, that is 806 of 2019. That is also subsumed in this ED proceedings. Now, these 3 FIRs are by the registrar of the societies.
Oh, I see.
It is the statutory FIR.
Right.
So these FIRs say that there is a scam and 3 groups have been made. One of the group belongs to the petitioner,
Right.
wherein he is also made an accused.
Right.
So therefore, the ED also says that he is one of the beneficiaries of the proceedings.
May I just respond to that straight away? May I just respond to that straight away?
when this ECIR was registered in pursuance of that FIR, ultimately C summary was filed.
Yes.
That attained finality.
Yes.
So that ECIR has gone. That is how this man is aggrieved, this man.
Yes, yes.
But there is no fresh ECIR so far as the other three FIRs are concerned?
No, because
Why?
I'll tell you the timeline, how the timeline goes. The FIR is of 2018. The ECIR is of 21. The C summary has culminated in 2022. So before there is a C summary, there are three.
This C summary takes care of the other three FIRs
No,
also.
no. It only is with respect to
About the other three ECI,
other three
FIRs.
other three FIRs was subsumed in that proceeding.
But what is this subsumed? What do you mean by subsumed?
Yes,
that
yes,
is the
that-
question. That can't be subsumed.
Therefore, Your Lordship, the High Court has considered this aspect, and High Court has said that when the first FIR was live and kicking, that is the 18 till 22, these three new FIRs have come into effect, which were part of the ED proceedings.
What happened in those three FIRs?
Those are still pending.
Investigation is
Yes,
going on.
still going on.
But there is no fresh complaint under PMLA.
No fresh complaint.
May I just respond to this? First and foremost, this entire concept of subsumption is not there in the PMLA, and neither it finds any recourse to any of your lordship's judgment. This is an absolutely virgin area of law. Whether can the ED subsume downstream subsequent FIRs? That's my first answer. Second, Vijay Madanlal. I'm so sorry.
Notice, yeah. We'll issue notice.
Very well.
Yes,
Deeply.
sir.
I'll respond.
Item 20.
Obliged.
What is this now, Mr. Manikandan?
May I please, my lordship. My lords, this matter had come up last week. My lords, your lordship wanted to, my lords, study the situation and my lords, take up the matter because your lordship pointed out two things. My lords, your lordship pointed out that the Supreme Court does not come under the A committee project, my lords, for which I had an alternative suggestion. I wanted your lordship, my lords.
21. Yes.
My lord, this is for extension of time by the learned decisions for carrying out the computation, my lords.
That's all. This is only for the extension. This is for extension of time for?
For carrying out the computation in terms of the arbitration award, my lords.
Then we'll extend time by a period of 3 weeks.
My lord, 6 weeks, my lords, may do 6 weeks because.
All right, 6 weeks.
Lords, liberty to the parties to apprise the learned judge, my lord.
It's always there, yes.
My lord, 22 is that matter of SIDCO, where your lordships were prima facie not with me. My lord, yesterday I had a detailed sitting. My lord, the officers were also there. And my lord, it was my mistake. I could not point out certain things which would go to the root of the matter. I'm saying that with a sense of responsibility. But I have prepared a short convenience compilation. My lord, some documents are new. Some are, my lord,
We have a slightly heavy board today. This might
take it up on, my lords.
Monday after we reopen.
Please, sir.
Monday after we reopen.
Yes, yes.
Accompanying
No difficulty.
A small fact, not they want to be.
All right, we'll see. We'll also see his note. We'll take it up on the Monday after we reopen.
My lord, there is
May I file a compilation, my lords, because
can
there are
also
certain
file.
maps that have not been filed on record.
All right.
That will
Yes,
clear
yes,
the
sir.
air.
All
I'm
can.
so grateful.
All can.
I've got a map ready, but I can.
There are some additional documents on our side as well.
Time, we have a heavy board today.
Yes, yes,
so we'll
my
just
lord.
not do it today.
Additional documents.
No problem.
Item 23.
But can we find additional documents?
You can do it. No difficulty.
Great.
In the accompanying yes. Grateful.
I'm so grateful.
So I beg to appear. If your lordship sees the relevant rules.
It says that, if you had got the 15% all India quota, then you would be eligible to apply. Now, you didn't get the 15% all India quota from a government medical college, AIMS, or central government institution. You went to Vellore.
Well, there are two
That's why you have been.
Yes, so there are two aspects. First, your lordship may see 8.2 at page 43.
8.2.
And your lordship may only bear in mind one aspect, that this is a PG course.
We heard this matter.
We heard.
Yes, my lord. So your lordships were pleased to, my lords, observe at that stage that perhaps you should challenge 8.2 also.
So now you have
which I
therefore.
have done. Now kindly see, my lords, what 8.2 says.
Page?
8.2 at page 43. What's the PDF page?
PDF page.
PDF page?
Just give me my speech.
You can read page 11.
Yes.
Main diary.
Lordship, please.
Where is it? Page 40.
May I read that? You should always keep PDF.
Second.
Sorry, Manata. I today don't have my iPad. I apologize.
Yes.
I'm obliged. This is a condition of eligibility. All candidates who pass the final MBBS degree course examination from the college situated in Maharashtra state and completed 1 year internship training by 15th of August 2024 from a recognized medical college included in the schedule as per the provisions of the NMC Act 2019 and the repealed Indian Medical Council Act 1956.
8.3 relaxes the rigor of 8.2.
Yes.
But it says, because 8.2 says you must have passed your MBBS degree course from a college in Maharashtra. Affiliated to the
That's correct. And
university.
8.3, what it says is, you must have two criteria. One is that you must be domiciled in Maharashtra. And the second criteria in 8.3 says, and you must have qualified from any of these three institutions.
15% All India quota
From any of these three.
Government medical colleges, AIMS or central government.
That's correct.
Now you did your UG from Christian Medical College, Vellore, which is not one of the three.
Yes.
That's the point.
Now, Christian Medical College, Vellore. Now, firstly, so far as the merits of the student is concerned, they are outstanding. Christian Medical College, Malos, Vellore, as your lordships are aware, ranks amongst the top 3. Now, I had even got into JNU. If I had taken JNU at that point of time, I would be, at that point of time, you had no such regulations in 2016, when I opted for Christian Medical College, Vellore. So I could have easily got into JNU. I also got into KAM in Maharashtra. But because I was getting something much higher in the All India ranking, I took Christian Medical College, Vellore. So my first submission is, Manoj, that 8.2 for a PG course, to the extent that it provides this particular criteria, that you must have done your medicine, Manoj, only from a particular college in Maharashtra, on the face of it is manifestly arbitrary.
Why? Why can't the state not say that, look,
yes,
you are now applying for a seat in Maharashtra from a government medical college in Maharashtra?
Yes, yes.
Right.
Yes.
Why can't they say that we will confine our admissions to those who have done their MBBS from our state?
So one is, Manoj,
otherwise students from all over the country will come there.
Then you can have a criteria of domicile. I am in Bombay. The criteria of domicile is one thing, Manoj. To say that there is a criteria here today, Manoj, you are eschewing merits for a PG course. I can understand undergrad. Undergrad, Manoj, several other aspects come in. But so far as a PG course is concerned, that's a speciality. The second is, Manoj, your lordship's judgment in 2013-10 SCC, page 237, paragraph 16 and 19, specifically deal with this particular clause.
8.2 says all candidates who have passed the final MBBS degree course examination from a college situated in Maharashtra state.
Yes.
And completed 1 year internship training by 15th August from a recognized medical college, etc., are eligible.
Yes. So
now they want to ensure that, look, these PG seats are limited.
Yeah.
We want to, as every state wants to restrict it to those who have done their final MBBS from their state. They don't want people from outside state because these are very limited.
So I am not outside the state. I am domiciled in Maharashtra.
Right, but you never completed your MBBS 5.
Maybe, because at that point of time, you didn't have this kind of a clause. I wanted to do my PG. I wanted to stay there. I got it in an all India ranking at number 3. Now kindly see, my lords, this similar clause has been construed by your lordships. In, my lords, this judgment, if your lordship sees 2013-10 SCC, page 237, we have a compilation. Now kindly see, my lords, this judgment, if your lordships.
Wrong about a state saying that you must have passed the final MBBS degree with from
Because
within the state.
for a PG, my lords, that has been struck down. Just see paragraph 19 of this judgment. Well, I can understand undergrad, but you can't really compromise merit. You can't compromise merit to this extent. I can understand even limiting it to domicile. Now kindly see, my lords, this judgment, my lords. 2023, 10 SCC, 2013, 10 SCC, 237. Your lordship first comes to paragraph 16. My lords, relying on Pradeep Jain. If your lordship sees Justice Pardiwala has that?
Yes.
I'm grateful. We now come to clauses 2 and 3 of the eligibility criteria in the information bulletin. Under clauses 2 and 3, a domicile of Uttarakhand who has passed MBBS from a medical college of some other state, having been admitted either through 15% All India quota or through the pre-medical test conducted by the state government concerned, has been made eligible for admission to a postgraduate medical course in the state quota. Obviously, a candidate who is not a domicile of Uttarakhand is not eligible for admission to the postgraduate course under clauses 2 and 3 of the eligibility criteria. Preference, therefore, is given only on the basis of residence or domicile in the state of Uttarakhand under clauses 2 and 3 of the eligibility criteria. And such preference on the basis of residence or domicile within a state has been held to be violative of...
Now that you are challenging 8.2 of the state's rule, why have you come here directly?
My lords, because of the time constraint. Now just see paragraph 19.
Well,
now paragraph 19 deals with this clause.
What?
This,
High Court Act.
well, paragraph 19 deals with an IP.
Why should we invent it? These are essentially individual students coming here under 32 challenging a state.
Because of the time constraints, my lords. Now the admission process will start. Just see paragraph 19. Well, just for a moment, your lordship sees paragraph.
Mr. Ahmed, you go to the Bombay High Court. The Bombay High Court can well deal with this.
Well, let me read 4 lines of paragraph.
Why should we entertain a petition like this?
Here also, your lordship.
Otherwise, we'll be. You can always go to the High Court and get this relief.
Here also, your lordships have entertained it under 32 months. This very judgment. Please see paragraph 19. Just for a moment. Just for a moment. Paragraph 19 months. It will thus be clear from what has been held by a 3-judge bench of this court in Megan Mehrotra that no preference can be given to candidates on the basis of domicile to complete the institutional quota of the state.
Let the High Court consider.
If such candidates have done their MBBS course.
Let the High Court, the petitioner, has an efficacious remedy of moving the High Court of Judicature at Bombay, the exercise of the jurisdiction and Article 226 of the Constitution. To stop. Since the challenge is to clauses 8.2 and 8.3 of the, what is it called? Admission bulletin? Of the NEET-PG 2024.
Yes.
Information bulletin issued by the state of Maharashtra. It is but appropriate that such a challenge is addressed before the High Court of Judicature at Bombay. So we therefore dispose of the petition under Article 32, leaving it open to the petitioner to pursue the remedy available.
Well, if I move the High Court with him,
the event is that the
because since the admission process will start,
we would request the High Court to take it up with all due respect.
Logic. I'm grateful.
24.
My apologies. I appear for the petitioner in item 24. On Saturday, my lords, I have been served with an affidavit in reply, the counter by the other side. May I seek accommodation of 2 weeks to file my rejoinder? They are challenging maintainability of my petition. I'll have to answer that, my lords, in rejoinder. My lords. Oblige, lords.
25.
Grateful.
I appear for the petitioner.
Who is appearing for the respondent?
Lord, I appear for the respondent.
Are you agreeable to an arbitration?
Yes, Lord. Lord, the only thing is, Lord, that it has to be in a neutral, non-biased location. So in the context of international commercial arbitration, we have already replied. We have said that it can't be India, it can't be USA, it has to be some other country.
Why? We can appoint. You both agree to, and what does the arbitration agreement say? In a neutral, non-biased location.
Exactly. Article 9, page 27.
Lordship, it does not talk about a country, it talks about a location. And if permitted, let me file a rejoinder to the reply.
No, but we'll appoint an arbitrator. Why don't you both agree to the appointment of an arbitrator of your choice? If you can both agree to one arbitrator, sole arbitrator, we can appoint once you have faith in the arbitrator, then it shouldn't be really a problem as such.
Very well. Can we, then, my lord, since a reply is filed, if we can sit together and find out possibility to explore this. Otherwise, if your lordships have, page.
We'll discuss with them.
If your lordships have page 51, we
How
have
much is the
suggested that
claim?
even
How
single.
much is the claim?
It's almost
2 crores 34 lakhs.
2 crores.
2 crores and 34 lakhs. Why don't
Yes.
you both tell us the name of an arbitrator? If you have both some faith in a lawyer, we can appoint a lawyer. It's not a very large claim, 2 crores and 34 lakhs. Together.
My lords, we don't mind if, very well, we don't mind if it's done in Ahmedabad, actually. Any honorable retired judge of the High Court, Gujarat High Court.
Mehta, what is this non-biased location?
Yes, my lord. Article 9, if your lordships have, my lord, page 27, it mentions in a neutral, non-biased location.
Then Ahmedabad is a non-biased location.
Yes, my lord. Because yes, Ahmedabad is a non-biased location. Yes.
Yes, we have
Because,
got-
my lord, I
So we'll appoint we'll say that they have no objection to the appointment of an arbitrator. We'll appoint Justice Akhil Qureshi as a sole arbitrator.
Oh, my lord, even can we suggest names from the Gujarat High Court, my lord, retired judges of the Gujarat High Court? We can give 2 or 3 couple of.
Qureshi was a judge of the Gujarat High Court.
Correct. That's true.
Akhil
Or even
Qureshi.
Justice. Very well.
All right.
Justice
Or even Justice MD Shah, Justice Soni. There are. I mean, we have more than 2 names.
The respondents have no objection. The parties have no objection to the appointment of a sole arbitrator. एक sentence कर लीजिए. Usual order आएगा. Hence, Justice Akhil Qureshi, former judge of the High Court of Judicature of Gujarat and of the High Court of Judicature at Bombay, is appointed as a sole arbitrator. But Chief Justice of the High Court of Rajasthan is a all right.
Very well.
May I please, my lords? It's a dispute between partners, and my lords, I'm a citizen. Yes, my lords. Lord, it's a dispute between partners. I am for the petitioners, my lords. Petition number 1 is the resident of Oman, my lords. That's why we are before my lords.
Services complete?
Yes, my lords. As per the office report, my lords, updated today. It's
What is the arbitration clause provide?
Well, it's on page 33. It says that the arbitration proceedings shall be conducted at New Delhi. Page 33 of the
How much is the claim?
No, the claim should not cross 3 crores, my lords.
Not cross 3 crores. Asha Menon, former judge of the Delhi High Court, and it will be under the auspices of the Delhi International Arbitration Center.
So very grateful, my lords. So very grateful.
27.
Obliged. Deeply.
Who's appearing?
This is the first appearance for respondent. My lord, our reply has been already sent to respondent for their inputs. Not may roll it over for a week.
Already take it on the Monday after we reopen.
Very well. So great.
Bombay High Court constituted the tribunal. You are for the petitioner.
My lords, I am appearing for the petitioner. My lord had already considered this matter on Thursday, and only to await the reply, this has been kept on Monday.
My lords, we have filed the counter. My lords, the dispute is also the subject matter. Now here,
So the tribunal now consists of three persons,
Three
Mr.
persons.
Sharma, Mr. Kemkar, and then Mr. Justice
Please,
Patil.
My lords can appoint a sole arbitrator. This is only about 8 odd crores.
How much is it?
About
Which is
800
the seat of, what is the seat of the arbitration?
Bombay.
Seat of arbitration is Bombay.
My lords, my concern is also, my lords, the subject matter. Here the goods were seized by the government, my lords. As far as we are
Because all
concerned,
that can
we
be, of
already
course-
supplied.
All that, of
We-
course, can be decided by the
That will be,
tribunal.
of course, dealt with by the
That's
arbitrator.
on merit.
My lords, but the problem is, my lords, as far as my liability is concerned, this is on record that we have supplied the goods to their forwarding agent. That forwarding agent, the goods were seized by virtue of the notification of the government, my lords. All the goods were subsequently used by the government, my lords. Those all masks and everything. So essentially, there are orders, my lords, we have already
Why
placed.
don't we do this? That if you are both agreeable, Justice Naresh Patil has been appointed as a presiding arbitrator.
Very well, very
We can appoint him as a sole arbitrator. That will be much
Most
easier.
certainly.
My lords, in fact, we have paid the fees also to the honorable tribunal.
My lords, I think
So that's
some
much
ad
better,
hoc
so.
amount has been paid which was only in respect of one particular hearing and as the order would reflect. In fact, the tribunal from the very first.
So why don't you then go to all the three? What is the
We
problem?
can go to all the three, no difficulty.
My lords, we would request if sole arbitrator.
All
can-
right. Learned counsel on behalf, appearing on behalf of both the usual order of both the, ऐसा लिख लीजिए, by an order dated 25 April 2024, the High Court of Judicature at Bombay, in a proceeding under section 11(6) of the Arbitration and Conciliation Act, appointed the nominee arbitrator of the respondent, correct?
Correct. Justice
stop.
Shantanu came.
The petitioner had already nominated its arbitrator. Full stop. Thereafter, on 16 May 2024, the two arbitrators appointed Justice Naresh Patil, former Chief Justice of the High Court of Judicature at Bombay, as the presiding arbitrator, as the third arbitrator. Full stop. The petitioner has now contended that the application before the High Court of Judicature at Bombay was based on incorrect legal advice, since the dispute is an international commercial arbitration. Full stop. The petitioner, full stop. The fact that the dispute arises out of an international commercial arbitration is not in dispute. Full stop. Next, both the learned counsel are agreed that a sole arbitrator may be appointed, having regard to the nature and quantum of the claim and in the interests of expedition.
Obliged.
Stop. Accordingly, they have agreed that Mr. Justice Naresh Patil, former Chief Justice of the High Court of Judicature at Bombay, shall stand appointed as the sole arbitrator under the Arbitration and Conciliation Act 1996.
And maybe my lords can consider these being administered through MCI, since this is Bombay.
The arbitration proceedings shall be administered through the Mumbai Center for International Arbitration.
And the fee shall be governed by the rules.
And the fees shall be governed by the rules of MCI.
Obliged.
Stop. Payments already made to the two other arbitrators shall, however, not be recovered by the parties. It has been agreed with, of course. Small, yeah. 29.
Obliged.
29, I'm appearing for the state of Madhya Pradesh. There is some further investigation going on, some documents on which I want to rely. Therefore, my lords may give me some time, for 4 weeks' time. He is protected, the trial is stayed.
Well, the application for vacation of stay has to go, Malad, because the FIR has been quashed by the High Court.
FIR has been quashed by the High Court.
Yes, that's the subsequent, that's a different FIR.
No, that is the one that for which you filed the application. Don't say that. You've asked.
Let it be on the next date.
No, but the FIR has been quashed. Where's the question of the application surviving?
Yes.
Malad, and see,
Application has
just
gone,
have a
that's
look.
what I'm told.
Have a look at page 29, what they are doing, Malad. Adoption in 2009.
There is
Sorry,
not much
Malad.
is said as far as adoption is concerned.
Malad, kindly see, adoption in 2016-17, offer in 2009, challenged in 2024, 6th August.
So that you want a little time.
But Malad, why should this application be there? It's FIR is
Application by them for vacating the stay.
That's right.
That we are not entertaining it today.
basis for that application is a subsequent application, which has now been
Quashed by the High Court, Manoj.
No, we are not vacating the application for we
But
are not
Manoj,
vacating
may
the
I
stay.
give me a
But
minute?
Mr. Raju says he wants to put some material on the record. We'll take it on the reopening immediately after.
Yeah, give me a minute, Manoj. Just kindly come to page 29. I don't see
What?
why.
Hold on. Allow me.
Trial has been stayed. Nothing is happening.
Mr. Sibal, we'll give him one opportunity to.
I don't mind, Manoj, but just have a look at
No,
page.
but they're registering fresh FIRs, Malaj. This is the malified intent. When the matter is pending here, why keep registering fresh FIRs? In this last one,
20
the High Court has
policemen.
found it to be malified.
20 policemen come, then they break open the house, Malaj. Just see what they are doing. Just see the photographs. Break open the home.
Squashed actually.
Well, the FIR lodged in August 6th.
This is not the subject matter of this.
No.
Today you have come against the order framing charges, right?
No, and therefore they are asking for vacation of this stay based on that
Based
FIR.
on that FIR.
We are not vacating the stay.
Very well.
Dr. Murli, we are not vacating the
What is
stay at all.
happening is they continuously harassing us. This is the whole problem.
Now, who is harassing
break
whom
open
and
the
who is
home,
torturing
Malaj.
whom? As a matter of fact, I'll point out, Manoj,
Anyway, let
That's
him.
what we'll do is we'll take it after the reopening, after the 1 week. On
Very
Monday, we'll take it up. Whatever he wants to file, let him file.
Very
Very good. Very good.
grateful.
Not for
Not giving a fixed date, Manoj. Week,
Yes, right on that Monday.
week starting on the 11th, Manoj.
Yes.
Grateful.
No, 1 week after.
Third, Gaurav.
11th, Manoj.
Third, they want it on the 3rd. We'll take it up immediately after the reopening.
10th, Manoj.
Yes,
First week.
that's fine.
3rd, we'll take it up on the 3rd.
This Sunday.
Third, I have some problem.
Take it up on the 4th, 5th. 5th, no problem.
The contract was concluded in 1991. The MSME came into
8 days. Why should we?
this problem was the judgment was not pronounced in the open court. By the time it was announced, we could not.
Delay will not condone this.
Lordship will issue notice on that, and Lordship.
Will not condone the delay.
The only problem is here.
News to their benefit.
The only problem here is, that it's clearly covered. 91 is the contract.
You have to open the door, Rajab. There's a delay on your part.
91 is the contract. This is the government company. It's a sick company.
The impugned order says you have to challenge it by following the procedure under section 34.
But challenge that says deposit 75%.
You have to
2
deposit.
lakhs is the amount. 2 lakhs is the amount.
You have to deposit it.
It's 7 crores now.
But
kindly say 2 lakhs is the amount. Where the government pay from? The STC is a very sick company.
I know.
Would your Lordship not consider one thing? I will.
The delay of 128 days.
Lordship will consider one. Lordship will consider. Lordship will consider one thing. The matter is coming up on the 21st. It's not covered by it's a nullity. What is a nullity? Admittedly a nullity.
We are not condoning the delay. You can't argue on merits to condone the delay.
Lordship, Lordship will not give me some time, extension of time before the 21st is the date, my lord. For deposit, I can't do it Monday, my lord. Monday I can't do it, my lord. Lordship will give 1 month.
A time for deposit.
Deposit, my lord.
Extended by a period of
6 weeks, my lord. 6 weeks.
By a period of 4 weeks.
6 weeks. And my lord, installments, 2 installments.
We've given you 4 weeks, yes.
My lord, the year has outlived its life. It was extension till today. But I'm told, my lord, the report is ready. If your lordships can consider extending for 2 weeks, Lord, it would be published.
All right. The Mr. Tushar Mehta, Learned Solicitor General, submits that the report of the high-level committee of experts is ready and would be filed within a period of 2 weeks.
Yes.
Time is extended for that purpose till 2 weeks ka time.
Correct. Grateful.
The High Court errs on 2 counts. Firstly, my lord, so far as the applicability of the model rules vis-a-vis the MP rules are concerned, my lord, Section 24 says, my lord, that the central government will only frame model rules, which will, my lord, be...
They say that because they had made an application for renewal of the license, therefore the deeming provision
under the central model rules.
Central model rules will apply.
Now, Both counts, my lord, in my respectful submission, the High Court errs me. Firstly, the model rules will not apply when the state has already framed rules under Section 25 of the Act. My lord, the model rules are only a model to be followed by the state government. The state government has in fact framed rules which does not contain a deeming fiction at all.
There's no deeming.
There is no deeming fiction.
So on that day, they didn't have the license.
They didn't have the license. Even otherwise, my lord, that the period is 45 days. They applied within 43 days. So consequently, even then, my lord, the deeming fiction under the central rules does not apply.
Sorry, what is that point?
My lord, the deeming fiction applies provided they've complied with the statute and have applied within a period of 45 days of expiry of the license. They did not do that. They applied 43 days prior to that. So consequently, my lord, in law, the deeming fiction will not apply.
My lords, for the petitioner, original petitioner, respondent number 7 here, my lords.
Under the state rules, there's no deeming fiction.
My lords, actually, that was not the ground on which my technical bid was rejected.
No, but the point is,
my lords,
ultimately the High Court holds in your favor and says your bid should be also considered.
Yes, my lords.
On the ground that under the deeming fiction, under the central rules, you will get the benefit, and therefore, once you had applied, your license is deemed to be renewed. Is there a deeming provision under the state?
No, my lords. That factor has been considered by the court, my lords.
But if there's, that means you didn't have a license at that point.
If the plain reading is done, my lords, that would be true. But then, my lords, the rejection, the technical bid was rejected on the ground that you did not apply within that 45 days, my lords, under the model. So once they apply the model rules and say that you've not applied the 45 days.
The fact remains you didn't have a license, right?
But then they applied the model rules, my lords. And they can't pick and choose, my lords. Para 23, this aspect has been considered, my lords.
To notice, yeah. You file your return, and we'll stay the operation of the order of the High Court till the next date of listing.
Please.
Notice returnable on specific date, pending further orders. Yesterday of the tax. 34.
Sorry. In a review petition, the appointment of the learned arbitrator is recalled. Kindly see page 469. The first day when the parties appeared, there was a specific recording by the learned arbitrator, page 469, my lords. May I just read 4 lines?
Yes.
Both the parties as well as their counsel stated that they have no objection towards my appointment as the sole arbitrator of the arbitral tribunal to act as an arbitrator, as ordered by the Honorable Patna High Court by order dated 1/2/23. After this specific stand taken before the learned arbitrator, and after that filing a counterclaim, and now today the stage is the claimant's witness is complete in terms of cross-examination. It's an advanced stage of evidence. I'm so grateful. There's one submission, methods. Now, it so happened that I had a bank guarantee of 15 crores. I had on the first day a stay on the bank guarantee encashment. 4th October, the order is issued by the Honorable High Court. I informed them on 6th that I have a bank guarantee, but then also I'm moving this Honorable Court. 9th, I moved. The moment I moved, within a few hours, they encashed the bank guarantee, my lords.
Now the money is gone, right?
The problem is I'm in deep trouble. I have a 20 crore bank loan, my lords.
So what we'll do is we'll issue notice and keep it right on the Monday after we reopen. You serve them Dasti and come.
I'm so grateful.
And perhaps on the bank guarantee, if we restore your arbitration, set aside this order of the High Court in review, you may have to apply before the arbitral tribunal for bringing that money before the tribunal.
My lords, for your lord,
something like that.
Understand, my lords, but
That will be in a section 17.
But in fact, if my lords is restoring the arbitration, then in my submission, the interim order granted by the arbitrator ought to be restored again. In which situation your lordship would consider? I moved an application already before your lordship.
Right after hearing them, but we'll issue notice in this.
But may I also be
on the Monday
serve,
after.
may also be appointed to serve the standing council because it's a state.
Liberty to serve the standing council for the state of Bihar in addition.
Highly grateful.
I appear for a miracle.
One more thing, Mr. Devesh, how did the High Court review its order under 11.6? There's an order under 11.6, right?
11.6, my lords.
There was a review.
And that too with a delay of 127 days, but even that,
Anyway, we'll
whether
see
they
it.
would have the power,
Okay.
I'm so
Just
grateful.
consider that.
I would, my lords. I'm grateful.
Please. Appear, my lords, in 35 for a medical candidate, my lords, who would have tried in the NEET successful.
The only thing is, look, her mother is engaged with the Nuclear Power Corporation of India. She is posted in Karnataka.
That's right.
Grandfather is from Karnataka. Father is employed with the electricity department in Karnataka.
In Goa.
In Goa.
Sorry, not Goa.
In addition,
not
in
in
her
Karnataka,
favor.
in Goa.
Correct.
We are dealing with Goa here.
Correct, that's right.
Now, technically, I mean, the High Court has taken a broad view, saying that there is an exception, right? There's an exception clause.
I'll just take your lordships through that. Now,
That
what is,
says
I am not asking for
you're a
annulment
child of government servant.
Correct. So I'll just point out, I am not asking at the outset. At the outset, I am not even asking for annulment of her admission. That is the first thing your lordship should take.
And she's not an imposter.
No, it's not.
Because
I'm not
her
claiming.
father, even today,
Correct.
Serves.
Continues to serve.
service in Goa.
And in addition to that, in her favor,
High
her
Court says she went to Karnataka for the reason that the mother was based in Karnataka. Mother was employed at the Nuclear Power Corporation. Therefore, she did her 12th standard from Karnataka.
Correct. Your lordships have obviously seen it.
Why displace a
your
young
lordship
girl
said that.
from getting medical admission?
I'll start submitting on that. Now, my lords, my first very important substantial submission is this. I am not seeking the annulment of her admission. That's point number one.
That's not possible.
I'm
Unless
not even.
we cancel her admission.
You will not
only
get
then
it.
you
I'm
get the
not
admission.
even asking for that. I am coming up with a via media, a suggestion, which is there in the prospectus. Your lordships don't even have to go beyond the
What
prospectus.
is that?
Now, please have page 96 for a moment. The prospectus, my lord, starts at page 72. I am referring to page 96, 97, and 98, where the categories are laid down. Now, the ineligibility of the respondent number 7, the admitted candidate, comes from paragraph 5.1. I am not going to rely on
But
that.
then should you not assert your own right to seek admission
Well,
rather than challenging the admission of
Your lordships will see, that's my second submission. 2 writ petitions have been filed before the High Court. One,
if you are otherwise entitled to seek admission as of right under the rules, why do you need to challenge the admission even to this girl?
I have applied through a writ petition. My writ petition is tagged with her writ petition. Merits of her writ petition are decided. Not a single submission of my writ petition has been adjudicated
You
upon.
can't gain admission unless she is displaced.
No, kindly see.
That's the problem. So now
I'm-
seats are all filled up.
No, please appreciate. Please have 90.
Seats would be all filled up. Therefore, you rightly challenge your client was justified. You challenged her admission on the ground that if she goes out, you are higher in merit and therefore you would be entitled to it.
Now, I'll point out. She's higher in merit. She is. This is for the last
seat.
seat.
And he is 45.
This is for the last seat. There are 44 seats.
Then
Please see
you call that
98.
If she is taken out of the fray, then the seat will go to
I am not asking for that. Please appreciate.
But how will you get an admission?
Well, please see 98. The answer is right there. See 98, my lords.
What is that?
There is a different category under which she could be adjusted. Serial number 5.7. There is a reservation for 3% seats for central government, state government, and PSU employees. Their wards, please see 98 for a moment.
Already filled out.
No, my lords. I am coming to the other one if my learned friend will allow me. Please see.
We'll not leave her in the lurch to be.
I am not asking,
just
my lords.
against some other category.
At the outset, my lords, I started by saying it. Third time I'm repeating with the greatest humility, my lords. I am not asking for her displacement. Take it from me. Please see 5.7, 5.9, and 5.1. 10. Please see that, please, with the greatest respect. 5.7, my lords, is 3%, my lords, is reservation for central government, state government, and PSU employees. There is another category where it is merely a case of adjustment of the candidate. It is nobody's.
She has not applied in that category.
Well, therefore, I am asking.
We have so many candidates who come here and tell us, please adjust my category, and we reject their petition.
We are referring to a candidate.
It's a correct judgment of the High Court.
May I just point out? Please see, your lordships have always.
Therefore, the facts are very, very stark and telling.
May I make this?
She is not a person who is an imposter.
Lordships are right.
Father employed in Goa, grandfather, mother, she went to Karnataka because, I mean, you can understand, the girl child wanted to be with the mother. And mother also what? Mother is not in some private sector organization. She is working for the Nuclear Power Corporation of India Limited.
I'm just showing the way forward. If your lordships will bear with me for 2 minutes. I'm not asking for that. Please.
We leave it. Thank you.
As your lordship.
Obliged. Well, my candidate is greater in age, number one. Number two, also belongs to the OBC category. I'm asking for some leeway in this. There is a way forward. I was wanting to show that to your lordships. As your lordship, please. Grateful, my lords.
Item 36.
I have a preliminary objection.
Lordship,
36, fellows. Can I have a
Lordship,
objection?
as the petitioner, may I just make my submission?
I have a preliminary
Then Dr.
objection.
Singh-
One
Lordship,
second.
he's
Can I
the-
make it?
Lordship, I think
Can
since
I-
you're
You're
the
not
petitioner.
I will not argue the matter.
You're not arguing merits in the guise of a preliminary
That
objection.
is far too difficult to camouflage it before lordships.
All right, tell us what is the preliminary objection.
The same, well, the office report says this. The same impugned order as in today's case came before a bench headed by my Lord Justice Narasimha. He heard at some length, issued notice and fixed on 4th of November. That's preliminary objection number one. So, Malas, it's surprising and no stay granted. After argue, we both appeared.
So, we'll place
Number
the-
two, Malas, number two. My learned friends have challenged the same order here without challenging the subsequent order by which they really agreed, 7th of October. 7th October by Justice
May I
Ranganathan.
just make a submission?
Harpriya,
Yes, your lordship.
this order the subject matter of a challenge before Justice.
Yes, I was going to point that out. I don't know why they preempted make.
Fourth
We are
November.
doing
What we'll
something
do is,
which is wrong.
what we'll do is this. We'll
Fourth
place it
November.
before Justice.
But tomorrow, your
November.
lordship, may I make a
On
submission?
Friday before Justice.
Lordship, it will be too late.
This is
Your
my
lordship,
lord.
that will be too late. May I just please make a submission?
All right,
Reading-
tomorrow before.
Tomorrow, it can be before Justice Narasimha.
Tomorrow
No
before
problem.
Justice.
It can be listed tomorrow.
Fair enough.
Obliged.
I'm obliged.
Obliged.
List before a bench.
There are two other matters also today,
List
lordship.
before a bench, so what is the matter which was,
The first
that
item
is,
office
HT
report.
Ispat, right?
The first, yes. I
That-
Civil Appeal 40604.
That is diary, I think.
No, this is,
Uh,
yes.
The diary number 40604 of 2024, arising out of the same order of arising out of the same impugned order of Aptel dated 22 August 2024,
Yes.
was listed on 23 September 2024 before a bench presided over by Honorable Mr. Justice P.S. Narasimha. Let's stop. The registry shall accordingly list the present proceedings before a bench
Tomorrow.
presided over by Justice P.S. Narasimha, preferably tomorrow after seeking.
Because we have a disconnection notice which we have got after. What has happened in there, there's no disconnection notice. We just requested to be tomorrow, your
Tomorrow
lordship.
we'll keep it tomorrow, no problem.
I'm grateful, most grateful, your lordships.
Can I have that?
Even the connected matters, your lordships.
They're coming up. Which are the connected matters?
There are some new more matters.
You mentioned before Justice Narasimha.
There in those.
Or circulate an email. I'll pass order on that.
I'll do that.
Those matters.
Lordship, there is one page I need to
All
read.
right, fair enough. Just circulate an email.
I'll do that. Lordship,
That listing is my prerogative. I'll place it before
Lordship,
Justice.
kindly consider
Agreed.
one page need be replaced. Wrongly, it has gone. Lordship gives me leave. I'll do that today, right away.
But now, if we are keeping it tomorrow before Justice Narasimha, just tender that one page and get an order from him.
All right.
I'm grateful, your lordships.
Yes, item 37.
Yes, Malas, I appeal this. Malas, can I just hand over, Malas, a little note to your lordship?
Yes. Sybil, can we just take a little
We are on KV.
break for 2
Yes,
minutes
yes,
and
yes,
come back?
yes, no issue.
Just for 2 minutes, we'll take a break.
No problem at all.
In case somewhere else, any of you can pass it over and then take it later in case you're called out somewhere else, either of you.
Obliged.
But the state in the public. Yes. So Sibyl
Because he was here.
Well, we'll just roll it. We'll pick it up the moment he is here.
Very well.
38.
Your Lordship, I request for a password in this matter.
Why have you come under 220, 32 over here?
Your Lordship, the senior who I'm briefing is on his.
Your writ petition was dismissed by the Delhi High Court for lack of territorial jurisdiction.
Yes, Your Lordship.
Why? And you now file a 32 petition here.
Your
You file a petition before the competent High Court.
Your Lordship, the only grievances that counselling are going on, and this court has intervened in a lot of cases.
Delhi High Court, right?
Yes, Your Lordship.
You went to a High Court.
Your Lordship.
Now you must go to the
file
correct High Court.
Your Lordship may pass over the matter. This
Petitioner would be at liberty to move a petition
Your
to
Lordship,
Article 226 of the Constitution before the jurisdictional High Court.
Your Lordship, just understand the grievance that
We have understood it, we've read it. Thank you.
The
Thank you.
Supreme Court has fixed the
39.
Ranjit Kumar is on his legs. May I seek a password?
Tag with that NHAI versus State Bank of India?
Separate. There's a separate issue in this.
Can I say this, my lord? The dispute is only between NHA and us. And we have, your lordship has guided us. We have now trying to sort it out. We have taken time. Their grievances, this board alone can decide how much amount should be dispersed as per the earlier order of NCLAT. And how could they intercede to it? And through an order. The NCLAT records are finding in para 11 to 13. We have given you ample time and opportunity for the board to resolve it. And what is there between me and NHA? We are sorting it out.
We'll hear Ms. Ranjit Kumar in a moment. There's something to be argued by.
Item 40.
Who is for the petitioner?
R1.
R1.
May I appear for R2?
Yes.
This is a factual position. It was a suit for specific performance on which limitation was one question. It is a question of fact and law. That is one. I also want to tell you, Lordship.
Last time their submission wasn't fair. We don't know. They've been filing.
Regardless of the question, my lord, whether the amendment to section 10 of the Specific Relief Act, which takes away the discretion, regardless of that, my lord, it's based on the facts, the entire suit.
So what are you going to argue?
So, my lord, what we are going to argue is that the basis of saying that time is the essence of the contract, because ultimately it is the application of Article 54 of the Limitation Act. Is it from the date the cause of action arose or from the date of refusal? Our case is it is 3 years from the date of refusal when the legal notice was given and you replied to it denying your obligations under the contract. Their case is that the original agreement from that date, if you take 3 years, the suit is barred by limitation. Now, the complete fundamental error in the order under or the judgment under review is they pick up an agreement which is not between the parties. Earlier, what had happened in the matter was the original owners had sold to them and they sold to us. So our agreement is of 1997. Their agreement with the original owners is of 94. So they pick up that agreement, one. Secondly, they rely on clause 21 of the second agreement between us and them, which effectively only said one limited issue. And what it said was that all that this agreement that we are concerned with is that the payment that we are making to you, the payments made to those original owners are of no consequence any longer because we have already paid them. That is them, they have already paid them, the original owners. This is all that clause 21 of our 97 agreement said. The judgment under review goes on to say on its own that the agreement to sell was dated 1994. In 1997, as per clause 21, which is the clause in question, you were given the last opportunity to make the payment. And because this was the last opportunity, time is the essence and thus the suit is barred. Now, my lords, two fundamental and grave errors. Firstly, 94 is not the agreement between us. The first agreement between us is 97. This is a clear misspoken fact.
Not with great respect.
This is like a first appeal.
The first agreement or the second agreement is out of time. My friend is now re-arguing the matter.
Sorry.
That you look at this clause without error.
I have to open my case.
It cannot be an error without a parent.
And let us put in a reply, my lord. Let us put in a reply. They took 6 weeks for additional documents.
In which case we dismiss the review. Can you just show us where have they relied upon the 94 agreement, which was not between you inter partes?
Yes.
Let us see that.
Please first have para 32. Just a minute. Para 32. And there are many other paras. I'm just showing one para because this covers both clause 21 and the 94 agreement. My lord, has para 32 on page 22?
Just a second.
You can show me the clause.
Para 32.
Yes. Coming to the aforesaid indicators, the language of the agreements make it clear that severe consequences of
the judgment.
No, this is on PDF 42, if your lordship wants that.
PDF page 29 actually. Para 32, right? Coming to the aforesaid indicators. This is
My lords have para 32?
Yes.
Coming to the aforesaid indicators, the language of the agreement makes it clear that severe consequences of forfeiture would ensue if the payment.
Did not take the correct dates.
Yes, my lords have para 32?
Yes.
Coming to the aforesaid indicators, the language of the agreements make it clear that severe consequences of forfeiture would ensue if the payment is not made within 3 months of the date of agreements. It may be noted that as per clause 21, the parties had entered into an earlier agreement to sell dated 19/3/94, which did not materialize. And accordingly, the agreed price therein is no longer applicable. It is in this context that the fresh agreement was entered into between the parties so as to provide a last opportunity for them to successfully enter into a sale purchase agreement. The aforesaid intention of the parties is made clear through clause 23 of the agreement to sell, which reads as under: the parties of the second part herein undertake on any pretext that they will not make any claim for enhancing the agreed sale consideration. Now please have clause 21 of the 97 agreement. So two fundamental errors. 94 is not between us. 94 is between the original owners and the people who have sold to us, the vendors, in this matter. And please see clause 21. The most important thing, please see clause 21 on page 118 of the SLP. Page 118.
Page 118. That is an annexure. Oh, it will not be in the review. It will not be in the review. No?
It's in the SLP, my lords, annexure P1 starting at page 109 at 118.
Agreement to sell.
Please, my lords.
Annexure P1, right?
Yes, my lords. Annexure P1 at 109. Please have 118 at clause 21.
That will be
at 118. The parties of the first part are not at all concerned to the sale consideration agreed by the parties of the second part herein, with the purchaser as already they received the agreed sale consideration from the parties of the second part herein as per agreement dated 19th May 94. And where does it say this is the last opportunity? This is the second agreement after 94. 94 was between them and the original owners. So the purpose of clause 21 was if the original owners have all and who are described as first party, because you've received money, so you can't take further money from the purchaser herein. And this is between me and them who are referred to as the second party in the agreement to sale. And we are the purchasers.
Party of the first part is them.
Is the original owner.
Oh, the parties of the first part is the original owner.
Owner. He is not concerned now. That is the purpose of clause 21. Now, please see the import of what that para I read out to say. 94, there was the first agreement. Then you could not pay in 94. So 97, the second agreement was entered into. And the 97 agreement, clause 21 said is the last opportunity. Now, firstly, my lords, 94, there is no agreement between us. 97, just a minute. 97 is our first agreement. Clause 21 nowhere talks about a last opportunity. My lords, in any number of judgments your lordships have held that if a judgment is based on clear misconception on facts and law, that is a ground for review under Order 41. This is a case because from that flows the consequential conclusion, that is, because the agreement was entered into 94, last opportunity was given in 97, time is the essence, and from the date of the original agreement, your suit is time barred. Our case is that after 97 agreement, we kept writing to you. We finally gave you a legal notice in 2000. You refused complying with it, and in 2002, we filed the suit. So time as per Article 54 of the Limitation Act, in our case, since time is not the essence, will start from the date of refusal, not from the date of original cause of action. And please keep in mind that 90% of the consideration in this matter was paid within the 3 months. Before 3 months as the original agreement between in 1997 provided. The balance 10% was not paid because they had to comply with a lot of income tax clearances and documents they had to give us. That's part of the ULC etc., which is part of the agreement. So that 10% was not paid. Now, if you thought that the agreement had come to an end, you could have sent me a notice terminating it. You could have returned the 90%. Because the clause only provided that if you don't comply in 30 days, then the earnest money will be forfeited. The clause did not say 90% will be forfeited. So clearly the High Court came to the conclusion in the matter that time is the essence of the matter. And if time is the essence, time is not the essence in the contract, and if time is not the essence in the contract, then we will see it from the date of refusal. Be that as it may, my lord, that's something.
Our court really holds the 94 agreement shows that what.
No. If the High Court does not, 94 is between them and the original owner. High Court simply says.
No, our court, I said.
Please, my lord, your lordships in this clause are saying, in this clause in 32 are saying, that the first agreement is on 94. This was the last opportunity to pay after that because clause 21 of the 97 agreement says last opportunity. Why does it say last opportunity? Because according to the court, the Supreme Court, the first agreement was in 1994. And since you did not comply with it, the 1997 agreement was entered into with clause 21 as the last opportunity. Please have 32 again for a minute, my lord. Yes, may I just read it again, my lord? Yes. So the whole logic of this last opportunity is that there was 94, there is 97, clause 21 of the 97 agreement provided the last opportunity. You still did not comply with it. Thus, time is the essence. Now that becomes the principal basis. And most interesting.
94 is not inter partes anyway.
Yes. And then, my lord, with great respect, then secondly comes legal notice. Now the legal notice sent by me clearly says that you right from 97 have not complied with what you are required to comply. In fact,
This is of the 1997 agreement.
Yes. And that was absolutely. Now, please have one more paragraph, paragraph 5, which I'm grateful to my learned friend for pointing out. Please have
paragraph
5. Para 5 on page 3.
Of the judgment?
Yes.
Yes, of the judgment.
Judgment of which
Yes.
review is sought.
The agreement dated, my Lord the Chief Justice.
Yes.
Agreement dated 19/3/94 and registered GPA in favor of respondent purchaser could not materialize. This is not with me. I have no 94 agreement with them.
We don't.
Parties entered into fresh agreements dated 26/3/97 and 27/3/97 herein to purchase an extent of so much. So the same error continues, culminating in 32. And then, my lords, the other ground to hold that time is the essence is, I give a legal notice. And the legal notice clearly says, from 97, I have repeatedly come to you. I've paid 90% within the first 2 months of the agreement being entered into. It's only 10%. And I did not pay it because you did not give the balance consideration. You've not repudiated. You've not terminated. You've not returned. You've not forfeited. You could only forfeit the earnest money. Now, and you started negotiating with other parties, and because nothing materialized with them, you again came back to me, and now the legal notice is being issued. The Supreme Court says that, look, in your legal notice, you said that they were negotiating with other parties, and because that did not materialize, they came back to you. Thus, time is the essence. Now, my lord, whether they were negotiating, not negotiating with other parties, how does it make time the essence? I want to show the legal notice to your lordships, and what is the conclusion? Time of the essence is based on two principal grounds. 94 agreement, 97 is the last opportunity, and because 97 is the last opportunity, thus time is the essence, and thus the suit is barred. Secondly, time is the essence because your legal notice on its own said that they were negotiating with other parties, and because that did not fructify, they came to you. How does that make time the essence? I don't know, but I want to show that legal notice, and I want to show the conclusion drawn that how could the Supreme Court ever have drawn a conclusion that time is the essence based on this legal notice and the interpretation that it is seeking to give to it. No legal or factual basis at all for this conclusion drawn. Please have, no, just a minute, let me complete. Please now have the legal notice.
So 10% is deposited.
I just want to read this legal notice out. It's important for your lordships to see. I deposited the balance 10% also when the suit was filed. The court directed me. I deposited my 10% then. There and then, although they had not complied with their requirements of documentary compliances, that order of the court was not appealed against, or depositing the balance 10% in the suit proceedings. Now, please have my legal notice, just 2 paragraphs and 1 para of the order under review. How could that conclusion have been raised by the Supreme Court? Please have para 2 on page 136.
Of the legal notice?
Of the SLP?
Yes.
Of the SLP, annexure P3, my lords.
Is the legal notice dated 8/2/2000.
Yes.
The due amounts pursuant to the due date as among mentioned agreement of sale dated 26/3/97 and 27/3/97 were attached with rider that you persons would be under an obligation to furnish all relevant statutory clearances, documents to my clients, but at the time of payment of the balance sale consideration within the said period by my clients to you person, you have deliberately refused to receive the same on one pretext or the other as the reasons best known to you, which were never disclosed to my clients. This aspect of common conduct lies exhibited by you persons is nothing but dilatory with an oblique motive, which our clients resent, and further an objective motive, which our clients resents, and further so and so. Then para 3. However, the due efforts by my clients proved little hope when you have strongly urged my clients to come up with balance of sale consideration in view of the fact that other interested parties are not available at the moment, end of Jan 2000, and thereafter you have promised to complete the transaction by executing the sale deed in favor of my clients. On 8/1/2000, my clients have bought the balance sale consideration to you and requested you to make arrangements for execution of the sale deed on convenient date in client's favor, but you have refused to accept the same as the situation prevailing was incompatible. This aspect was not convincing to my client. However, they have expressed by their acts, by showing their willingness for the performance of the said agreement or sale mentioned above, adhering to the said conditions. The conduct related by my clients for the performance of the said agreement is their willingness at all times and also non-adherence to the said terms and conditions of the completion of transaction, either for specific performance of the agreement or for return of the part of the substantial sale consideration is lapse on your part, for which our client was suffered and is suffering. Now again, our clients through this notice express their willingness to complete the sale transaction by paying the balance amount for specific performance. Hence, I hereby direct you to receive the balance sale consideration at my client's office mentioned above within a week from the date of receipt of this notice and to execute a sale deed said lands as mentioned so and so in favor of my clients. And now please see, they pick up just one para 2 is ignored, para 3 is picked up, reproduced in the judgment under review. And please see what the Supreme Court says. Please have para 60 on page 39. Yes, my lords, have para 60 on page 39. Have para 60.
Yes.
The notice dated 8/2/2000 issued on behalf of the purchaser implicitly acknowledges the fact that time was considered as the essence. Even by the purchaser themselves, and due to breach of the same, they sought novation of the agreement to sell in the following manner. Then that para is reproduced, which I read out of context. And then para 61, aforesaid notice at best reflects an intention by the vendor to renegotiate the terms, which was not accepted in toto by the vendor. Well, the whole case is about being disbarred and disentitled on time being the essence. The Supreme Court, contrary to the High Court, and I show your lordships the High Court judgment in detail, holds by time.
So whole year.
To show one more paragraph, please have para 34 also now.
Subject to my filing a reply. Lord, I should be entitled to file if I'm entering appearance today.
No.
The matter is not
Letters to the registry.
I didn't want to get into this today. They have been writing letters to the registry, and on the last page, just a minute, someone appears on their, someone appears on their behalf and says, I'm not familiar, this matter has come up after so many days, we are not aware of who's there, who's not there, these people live on far off places. They take a date on that day, and today come before your lordships with 5 counsels to appear on their behalf.
Where's the tearing hurry?
And
the tearing hurry is that you should not deal with the property.
Your lordships are dealing by the judgment. That is not a healthy practice. They filed with you. They kept without pushing it. They kept it in freeze. Then without taking it. Then the other judge retired. The judgment of my lord, the chief justice.
My lords are well aware because of open hearing.
Your
One
lordship,
minute, I
my
will
lord,
not
the
show
chief
it.
justice said there should be an open hearing. My lord justice
Yeah, open
told you,
hearing is
then
much
you said
later.
no open hearing. My lord justice Mishra concurred with the chief
That's
justice.
all right, but that's
Then
happening
there should be an
now.
Open hearing.
You
That
are
is why
taking-
this time was taken. Please don't make incorrect statements.
Justice Narasimha.
And Justice
This is what
Narasimha
your plan
refused
is.
in the matter. That's why the time was taken.
That the judgment is of 22. We are today in 24. If you were
Review
followed,
is all within
you would have
limitation.
got the review listed at the appropriate time.
And you want to
never
deal
did.
now with the property the way you
Anyway,
want to. That's the
anyway,
tearing hurry.
I want to put it in a reply, but subject to that, I want to show you 2 or 3 things.
Yes.
Let me show you. Now,
Manoj, can I show one paragraph which is important for your lordship?
This, you formulate in
Yes.
say a note of about 2 pages.
Yes.
You've already made clear what you want to argue in the review.
Yes.
That this ex facie,
Yes.
the judgment of Justice Krishna Murari suffers from an error apparent on the face of
Yes.
the record.
Yes.
You have formulated it.
Yes.
You give it to them.
Yes.
That's the point which you want to urge.
Right. That's right.
You prepare a note on the basis of the record. We'll keep it on Friday. You give it to them
Yes,
by
fair enough.
tomorrow morning.
Yes.
Put it on the reopening.
No, my lord, keep it on Friday.
We
Please
keep
have it on Friday. Yes.
They will, and they will be confined either
I will confine.
either we dismiss it on that because we have not formed a view.
I'm only asking for Monday.
No, my lord, Monday. No, please have Friday.
We will.
My lord, I have some problem on Friday. If it can be Monday. Why should it not be Friday?
Georgie,
Next Monday, my lord.
let's not say much about matter waiting 2 years. There's a lot to be said, which we don't want to say right now because that affects the dignity of the court. We will allow them to place on the record the short 2 submissions which they have made. We will not allow them to transgress those submissions on the point.
Fair
of view.
enough.
We are not with them. That's the end of the
If
matter.
your lordship wants Friday, then Friday.
Keep it on Friday.
Then I will circulate my note, my lord, by Thursday. Once I get their note.
Yes.
Your lordship may have.
Please. And my lord, in the meantime, let them not deal with the property and make my review in front of us.
Mr. Neeraj Kishan Kaul has urged specific issues, 2 specific issues.
My lord, there's a third one also.
Mr. Kaul,
Yes.
you don't want to say anything about para 36 and 37?
That is all, my lords. I
didn't argue that.
My lords, I was about to come to that. That's the third one I was saying. That's all that I'm saying, that the section 55 of the contract.
Mr. Neeraj Kishan Kaul, learned senior counsel, appears on behalf of the review petitioner. Full stop. Mr. Mukul Rohatgi appears on behalf of the first respondent. Mr. Mukul Rohatgi, learned senior counsel, appears on behalf of the first respondent, while Mr. Harishan Salve, learned senior counsel, appears on behalf of the second respondent. Full stop. The petitioners shall, the petitioners have clarified in the submissions of Mr. Neeraj Kishan Kaul and senior counsel, the 3 grounds on which the review petition is sought to be maintained have been urged. Full stop. In order to bring clarity to the ambit of the review petition, we permit the petitioners to serve on the respondents by 5 p.m. Tomorrow a copy of the grounds on which the copy of the submissions on the basis of which the review petition will be pressed. Full stop. No further submission apart from what is set out in the note to be circulated shall be permitted to be urged. The respondents will be at liberty to respond to the note no later than by 5 p.m. on Thursday ka date list on Friday.
And my lords, let them not create third party interest in the meantime.
Let's have gone
My
back.
lords, this has happened many times. my lords.
Respondents shall not create any.
I don't know, my lord, whether we have or we have.
Shall not
All the more, all the more.
third party rights between the date of this order and the.
That's fine.
Grateful.
on which the petition is.
Grateful, very grateful.
Mr. Sibal, you're 38, right?
Yes.
37. Is the other side here?
Yes.
Yes. Mr. Shyam, Mr. Niranjan Reddy, they are not here, they are in legs in some other.
All right, when you're all here, just mention it, we'll take it up.
Well, it's 2 o'clock, the exam is. It doesn't
My
matter.
lord, students are already in the exam centers.
Yes.
12:30 was the cutoff time. My lord, they are already inside right now. My lord, it's an interim order.
There's a very.
Mr. Sibal, at this point of time, how can we create, there'll be a chaos if we intervene at this stage. The
So the
students are already in
problem
the
is-
examination center.
I appreciate that, but the problem is, Miller's, that whatever, the GO itself is ex facie against the judgment of this court. Ex facie.
Exam is to take place at.
But what do we do, Miller? Therefore, all these people will be left out. Miller, they'll be out. Many of them will be over it. After 14, kindly see. I just told only one fact. This exam has been held after 14 years. As per notice.
High Court has
One-
made
Just
the-
allow me.
Let me say that,
After,
open.
after 14 years, this exam has been held, Malas. The reorganization took place in 2014. 10 years after that, it is Group 1 post, Malas. It will never be filled again. So we lose our chance permanently. Now, Malas, I'm not asking for anything. We want only a postponement so that the matter can be decided so we don't lose out permanently. If they have waited for 4 years,
How do we postpone an examination for the Public Service Commission? Which would be extraordinary for us. to do that.
well, thousands of persons are excluded.
Can-
And they are scheduled caste, scheduled tribes, contrary to Dipendra Yadav. Your Lordship knows, Malas, the adjustment. I understand.
Service Commission examination. we
Then,
can't-
Malas, they must allow us. They
Result
must
is
allow us
subject-
then,
result
because
is
we are
subject to the petition
candidates who have been discriminated.
We'll say that all further steps which are taken will abide by the further directions, and including the further directions that may be issued by this court and subject to the result of these
My
proceedings.
lord, the High Court has already said that, my lord. The results are made subject to the result. Please have page 8 and 9, my lord. It's kept for final hearing on 2011, 2022.
The
2011,
High Court is
2022
still-
means
High
what?
Court
Exam is
still-
over, I will not be able to do anything.
High Court is still seized of the matter.
Yes, my lord. Counters directed to be filed. Public Service Commission already filed its counter. State is filing its.
That's not
counter
the
in 3
point.
days.
The point
My lord,
is,
21st October, my lord, the matter is being heard. High Court asked the commission, how long will it take? My lord, exams today, they said they need 3 months for the purpose of declaration of result. High Court assured them that the matter will be heard and decided, my lord, in the shortest possible time. It's coming up before, my lord, a very fine judge.
fine, Malas, and then no result, because the result will be in 3 months. Let it be heard today.
But they are otherwise also going to take 3 months before the results.
Yeah,
are
therefore the matter can be heard.
Therefore, if any order is passed, the results will be affected accordingly.
That's why I said, Malas, therefore I said that your lordships may have them decide the matter
Lord, students have reported
before the
for
3 months
examination.
result.
We'll say that the special petition arises from an interlocutory order of a division bench of the High Court for the state of Telangana, dated 16 October 2024. Full stop. The High Court has specifically clarified that any selection which is made in pursuance of the examination which is to be conducted by the Telangana State Public Service Commission for Group 1 services
Yes.
One services.
shall abide by the final outcome of the proceedings. The proceedings have been listed before the High Court on 20 November 2024. So the court is apprised of the fact that the examination is due to commence today
Yes.
at 2 p.m. and students have already reported at the examination centers.
Correct, my lord.
In this view of the matter, we are not to consider view that any further any interim order in these proceedings would cause substantial dislocation in the conducting of the examination, which we are disinclined to do. So the High Court has already clarified that any selection which is made hereafter shall abide by the final outcome of the matter. To stop, however, we'd request the High Court to earnestly endeavor to take up the petition
Before the results are
before
declared.
the results are declared, and preferably on 20 November 2024, when the petition is to come.
Yes.
Before the result is declared, my lord has said.
All right.
Mullahs, the only one further request, Mullahs, since some of us are not allowed to sit for the exam, supposing the High Court decides in our favor, at least, Mullahs, then at least some exam be
That
conducted.
the High Court can give you whatever age relaxation or something like that.
Not in
That
the
you can urge before the High Court. That's a question of modulating the release. 41.
Wait, please, my lords.
Yes, Mr. Raghusan.
My lords, in this matter, this concerns the issue of the madrasas. Your lordships will recollect. Pleadings are complete in this, my lords. The compilations are ready. We're ready to argue, my lords. So, my lords, my submissions are on file, my lords. But before I start with those submissions, I'd like to share with my lords this communication, my lords, from the National Commission for the Protection of Child Rights. And with respect, I'll point out, my lords, that this communication is subsequent to my lord's interim order, fairly detailed order. This is subsequent to that order. May I just read this out, my lords?
For relocation of the students, right?
Yes, my lords.
This morning we have stayed a series of communications of the NCPCR.
Except this, my lords. This was not stayed in the morning. I was here at item 10 with the unaided madrasas. This was dated 11th October 2020.
But you argue your main matter now. This is in consequence of the two orders which we have stayed, right?
Yes.
After the orders of
After.
our court stay.
Yes.
Now you open your case, you tell me what your
I will, my
contention is.
Grateful, grateful. My lords, my written submissions, my lords, are on file. If my lords will, there are 4 sets of submissions from 4 councils.
Are they in the additional diary?
My lords, this is volume 1, written submissions.
Yes,
from
we
the
got
petitioner.
volume 1.
Yes. And mine start, my lords, because my propositions are listed there at page 33.
Yours is volume 1, right?
Volume 1, my lords. Volume 1 for the petitioners, my lords.
Yes.
Yes. My lords have that.
Dr. Guruswamy, yes.
Yes.
Page 33.
33 onwards, my
Yeah,
lords. They're fairly brief submissions. My lords, before I take you to my propositions, I just want to make one point.
Can
Before
you
I
show us the act? Can you
Yes.
show us the act? It's a
Yes.
state act, right?
Yes, my lords.
So can you tell us the ambit of the state act?
Yes.
And what that act really does and what the High Court has held? I think in our interim order, when we issued notice and we
Yes.
stayed the judgment of the Allahabad High Court, we had formulated the points which.
That's right, my lords. My lords, so shall I start with the act then, my lords?
Let's look at the act
Yes.
first, because
This is
in
volume.
a PIL, the High Court has set aside the entirety of the act.
Yes. Yes.
Am I right, Mr. Natraj? The High Court set aside the act.
That's right.
Though as a matter of fact, the state of Uttar Pradesh had supported the act as a legislating
It's
body.
our legislation.
Yes. So, my lords, I'll take you straight away to that. But before that, if you just go to page 35 of my submissions, I have extracted the act there, my lords.
35 of your
35 of the submissions, of my own submissions, 2 pages over, my lords.
Yes.
The propositions were at.
Object and purpose.
Yes, yes. So, my lords, may I just take you, my lords?
When we come back after lunch,
Yes.
just give us the bare act.
Very well.
If a soft copy of the bare act
We
is
have-
there, because that's the essence of
It's in volume 4A, my lords. I'll take you through that. Page 33, volume 4A. I'll take my lords to that.
Page 33, volume 4A.
Yes, page 33, volume 4A, my lords.
Yes, we have it here.
Yes. My lords, please see, my lords, the object and purpose page.
We'll come back after lunch.
Yes, my lords. Grateful. Grateful.
Just about 15 minutes, what is the essence of the challenge?
Absolutely, my lords. Grateful. I will.
My lord, may I make one submission? I just heard from my lords only that there are some more communications, some issues are also pending against NCPCR, which was stayed. We were not advanced up, so I'm not aware. If issues are similar, can we have all together?
Not necessary. High Court has set aside the validity of the act.
Lordship.
We have to see if the High Court is right. That's all.
Lordship.
admission of liability by you to him. You say, because I admitted my liability, therefore there is no dispute. Can this be?
Lord, may I only make two submissions? Lord, may I make only two submissions? Lord, may I make only two submissions? One is...
And even on law, you're not right, because the word which is used is breach. Breach of an admitted liability would always also give rise to a dispute.
But before 1 o'clock, that's all.
Respect, Lord,
37.
If we look at
37.
section 7 of the arbitration
No,
act,
but the
it says
Telangana
there has to
matter.
be a dispute.
We'll take
I'm
it up
saying
this-
I have
that's why
to
we're
pay.
telling lawyers,
And I have given
hurry up.
much prior to commencement of arbitration, Lord. I have given a schedule.
We can't give you take such a narrow view which will defeat the purpose of the Arbitration Act.
And then, Lord, there is a contradiction also in the award itself.
Thank you.
That evolves on only
Section
the
15.
husband and the
But
heirs
Lordship
of the
has already
husband.
taken a
My
view
lords
on
have
this.
appointed me
There
as
is
a
a
mind,
judgment
because
which
it's
has not
short
even adverted
issue.
to by the
All right,
honorable.
I'll consider. Thank you.
My lords, I'll just give the number to the.
There's a matter of Vidarbha power. There's a matter of Vidarbha power, which is in CRP.
Please,
CRP has to be issued. The matter before my lord, it's 109 last week. It's a very short matter. It will decide the fate of the company in future.
Lord, here the
because it has to
question is,
collect
my lord, whether the
change in law
state
benefit.
government,
matter
with
which
regard
somebody
to
had
its
mentioned, I think
sales
Yes,
tax.
my lords,
I appear for the appellant, my lords. I
I
appear for the appellant, my lords.
And me or Justice
My lords.
Anyway, it will have to be heard by this bench now. Yes. Because to notice here, because question is whether sales tax dues of the state government will rank over the
May please, your
acquisition.
lordship, I
You're
would
for the
like to
government.
mention
And you're saying that
the case titled as
you are
Likma
relying on
Singh
Rainbow.
through LRs versus Financial
Up for consideration
Your
before a
lordship,
legal
this is a
impact.
civil
Anyway,
appeal
we should-
which we
it's a
have.
question
Your
like
lordship, the
leaving.
eviction notice
You
has
should
been
know.
passed, and the petitioner are directed to evict
No,
that
sir, we'll not
particular
entertain this.
land
Thank
by
you.
22nd itself.
You're saying that, that you're challenging.
By
you're
financial,
saying that
actually, this is a
term
High Court
Hindutva
order which has
to be
been passed.
replaced with the phrase
Yes,
Bharatiya
yes, your lordship.
Samvidhanatva
Yes, your lordship.
or Indian Constitution.
And
It's a civil appeal.
Please,
Your lordship, this, in this matter, the petitioner was directed to eject that particular land. Actually, this land.
Item 5.
Yes, yes, your lordship.
It's a fresh matter.
Dekho bhai, kya
I'm
hai?
praying for some time.
Your lordship, one more request.
Two things,
One
my
more
lord.
request.
One, that the consignment booked was admittedly overloaded.
One, what you are saying that
There's a single judge order
ground
of
A you have said
the Patna
that
High
the
Court,
judgment of the High
which has
Court
said
is
that there
per
has
inferior,
been wrongdoings in the
view
Bihar
of,
Cricket
their
Association
own
with the
judgment,
selection. It's a
India
fresh
versus
matter.
Meghalaya. Are you
The
pressing
first
that
match
ground?
is on
That
26th.
also
The
because
selection
it is
committee has been
103.
thrown overboard.
Honorable High
Some
Court,
early
my
days.
my
lords, this
coordinate bench
pertains
has
to my
held
life and
that
liberty. I've
the
yes, I've
notification
circulated
of
a letter
50
yesterday.
stations
I've
is not confined
I have
for
surrendered before the court.
for
I'm
charges
very
terminated.
Total amount involved in this case.
I am making 1 crore 56 lakh odd, my lord. And I also need to place on record circulars which say that 50
It is showing on 4th November
It's already on board on 4th of November.
Let it not be deleted, my lord.
Yes.
This is a challenge to Rajasthan Judicial Service matter. My lords. It is listed
It's on
at
board today.
plus 9 more students have approached before your lordship. I have circulated a letter, my lords. It might not reach today, my lords.
Look, we have got about 7 High Court says that we had asked for you cannot charge English essay examination to be of the goods, the papers to be produced
For
of
that
all
purpose, I have documents
candidates
to
who got
show
less
that
than
the
15 marks.
consignment book was
7
overloaded.
trunks have come
That
here.
would go
When
a
the
long
matter
way
is called out, we'll
to
examine
charge
it. You be there when the matter
overloading
is called
charges.
out.
my
Your
lord.
lordship, this is a one more
upload the
request.
goods in the
Lordship, the
first
stay
place.
shall
Why
be
did you
granted till
permit
the
it?
dismissal handle,
Wrong, my
lordship.
lord.
That's
Fine,
fine.
finish.
But not
Your
overloading
lordship,
charges.
Now we have gone.
If he has
Item
booked
5 and 30, therefore we'll dismiss. 30 is the same, no?
yes, my lord, same.
5 and 30 will dismiss. Yes.
Statutory appeal.
Petitioner.
This
Mr. Ramadi, purely property, the hotel premises are in Ahmedabad. Parties are and the High Court has said that the 180-day commissioning period should begin from 3rd of May 2000.
The sole arbitrator, because the PPA is categorically
Juridical
signed.
seat will be
If your
Ahmedabad.
lordship sees the date of the PPA,
It's a possible view,
completely
Mr.
immaterial.
with
Once
respect,
there's a
there's a
party
divergence of
autonomy,
views,
once there
firstly.
is a
The
clause
KRC
of
held in
place
my
of
favor.
arbitration,
I know, but
Your
after
lordships have
BGS
already
and
issued
BDR,
notice
your
on a
lordship.
what
similar
decisions
matter.
make whether
Where the
the
same issue
arbitrator
arises.
appointed by the
Because
judge.
So
the
that batch of
law,
matters,
which
I'll just pass on the order
clarified
in a civil appeal. Now,
That was slightly different, wasn't it? Or is it an
will be
identical
upset.
point?
No,
You
one
entered
of the
into a
points is identical.
sublease
One
for
of the
hotel
questions which
premises
arises is
situated in
when does the
Ahmedabad.
period of
So
180
kindly
days
see,
run?
Has
my
clearly
arbitration
found
clause,
that the
give the
commission
charge, no?
specifically in this case,
Lordship,
para
so
9,
kindly see this.
approved my
This is a
PPA
conflict legal
after they
petition.
had passed the second generic tariff
expressly
order,
uses the
which
word
curtailed the
place.
first generic
But-
tariff order.
I'm
And
just
then
explain to your lordship it's
PPA
what
was
the,
approved on
what
3rd
the
of May
law is
2000.
and
A day after.
relegated to a law which was prior to BGS Soma.
Tariff
Lordships may
order was
kindly
2nd
take
of
this
May.
That's
chart.
right. So
This is
even
the
after
conflict of
curtailing
views,
the
and these
tariff
are
from
all
9
the
rupees
views
to
which have been
520,
held
they
and
approved my PPA,
concurrently
which had a
held
9
and followed
rupee
after
tariff.
BGS Soma
So that's what the
consistently.
APTEL found.
But that is why, Manoj, we made a mistake. Just let me just
I'll
place my
explain that
point.
because BGS
If your
Soma
lordship
very
sees,
clearly
King,
clarifies
a very
that if
important
there are
Mr.
two
Yes.
clauses,
that you paid at the rate of
shall be governed by
9.56
the laws
rupees
of
absolutely.
per
India
So
unit
that is
until
and shall
1st
be
of
under the
January
jurisdiction of the
2017.
courts at
So
amenable.
that
once
is
you
exactly what is
paid
explained
him,
by
we
Justice
made a
Radaman
mistake,
in
Manoj,
BGS
because
Soma. He
Manoj,
says that
just
there
let
are
me
so why
two
should we not
clauses,
give the
two
benefit to a
sections.
citizen?
One is
No,
section
with respect,
20,
because Manoj, he is
subsection
otherwise
3,
getting a windfall.
and there is a
The
section
tariffs
2,
are fixed,
which
Manoj,
defines
depending
courts.
Why did you
These
pay
are
him
for
until
two
1st of
separate
because we
January?
made a
purposes.
mistake, Manoj.
As far
Now,
as
Now, continue the
venue and
mistake
seat is
insofar as he's
concerned,
concerned. Why
it
should
is
we
connected to
ultimately,
party
look,
autonomy.
some
And the
fairness to a citizen also
arbitration
has to
and
be
challenges to
so
arbitration,
now
the
just let me
appointment
place
of
the point.
arbitrator
Previous
will
tariff is
all
not
be
out of the hat.
relatable to
It's
the
based on
place
Let me just
which
place
is
the point, Manoj.
equivalent to the
I
seat.
won't take
Now,
more than
this
1
is the
minute.
view
Yes.
which
Let me
has
place the
prevailed
point, if your
now, and
lordship
prior to this view
Now, Manoj, the
was that if
guidelines
there
make
are
it
two
clear. The
jurisdictions,
guidelines
that
are
was the
7/11,
Balco group, that if
2014. If
there
your
are
lordship
two
sees page
jurisdictions, then
88,
either can
the
be invoked.
guidelines make it
This
clear that
honorable
the
court has
commissioning
said,
must be within a
looked at
period
also
of
by
Manoj,
the-
180
no, it
days.
cannot, your
Now,
lordships.
kindly see the
Let-
facts of
Ultimately,
this case. The first
Lordships will give me
PPA
2
with him,
minutes.
Manoj,
Lordships will
is
sit
But
31/1,
have held.
we have to always
2015,
make
which is only Manoj
business
for
sense
50
out of any
kV.
contract.
Your lordship
Business
gets
sense
that?
only,
Now,
your
perhaps
And
for
lordships.
500
Business
kW.
sense
now
only.
we give him
Based
the
in
first
Ahmedabad.
extension
And
on
third,
5/7/2015.
give him multiple extensions.
Multiple
It's a
extensions.
jurisdiction
Now, Manoj,
clause. It's
finally,
not the
the
arbitration. And
PPA
let me
is
just
in
show to your
with the
lordships.
enhanced
Place as a-
extension for
Lordships,
1,000, Manoj.
this will create
On
havoc. And
5/1,
if your lordships will just
2016 for
give
the
me the
enhanced
indulgence
capacity.
of
That's
taking
page
this
20.
chart.
It's my
Consistent.
case, Manoj,
Arbitrator
that the
appointed
period
is a
of
former
180
district
days
Your
will
lordships,
run
that's
from
besides
the
the
date of
point.
the
The
PPA.
point is this, that
That's my case
I
on
am a
law.
national.
The modified
No, I don't
PPA
want to
Yes.
delay. Your lordships
approved
will
on 3rd
appoint
of
an
May
arbitrator
2000.
today. I will go to the
Before
arbitrator. I
that,
do not
he
have a
had not
quarrel with
understood that
application
to say that I can't do
appointment.
any
In fact,
work.
I want an
On
arbitration. I have consented.
4/4/2016, there is
You
a
are
report
not saying that
that he
arbitrator is
continued with the
biased.
installation even in the meanwhile.
An
Page
exercise of
126.
jurisdiction, which
After
is
that,
contrary
Manoj,
to
now
the
just
law,
see
itself goes to
the
lordships will give
express
me 2
terms
seconds.
of Manoj, the modified tariff order. If your lordship will be
Lordships
pleased
will
to
just
see
look at
page
para
131.
82.
It expressly says, Malord, that so far as new
kindly see.
PPAs which have not been commissioned up to the
It's
date
not
of
a
the
question
tariff
of law.
order and which are to be
I'll-
commissioned in future,
I'll
those
just
PPAs
give me
will
a
get
minute, your lordships. The reason why I'm pressing is for a particular
That's correct.
reason, not to concern with my parties.
Therefore, once the approval comes, it relates back to January.
No, with respect, Manoj.
That's the point.
The lordships will
Just
then
see the
clarify.
terms, Manoj. Just see the
Item
terms of the
17,
tariff
issue
order
notice
at page
on
100.
delay and
Just see
tag
one
it with
page.
that other
What is the
matter.
total
Your lordships,
quantum?
may I just clarify?
No, no, no,
Seek
Manoj.
for
It comes to
clarification because
approximately the
now
overall
Item eight.
financial liability is 13 crores. And it's only not limited to this case, because what happens is,
See, the thing
Manoj,
is
they
that
are getting,
on the one hand, we say rooftop solar, and
Manoj, they are
people do
getting,
this in
Manoj,
high
let me
street.
explain. They are getting a windfall for this reason.
Somebody makes a windfall. That's what business is all about. But question is whether we should interfere merely because he's getting some financial.
The question of law that arises is just see, Manoj, the express terms. Just see the express terms, Manoj,
Thank you,
that page.
Mr. Ahmed. We've crossed the
On
one.
the other
side.
I don't think, my lordship. As your lordship, please.
In the Bombay High Court, we had a very distinguished judge, Justice
The
Dhanuka, who
question
used to
here,
say
Lord,
operation
was
successful,
striking at
patient
the
bid.
root of arbitration law.
You went only for an order
Whether,
for
Lord, there in an
expediting the hearing
admitted
before the
situation
DRT.
where, Lord, even prior to commencement of arbitration,
Exercise the orders
I
in your favor,
admit
which were
the
never
liability.
questioned. 34 dismissed and 37 dismissed.
Lord, all along,
You know
the
what?
problem is
I
that
read
all
your
the three
petition
forums,
twice
Lord,
over
did
because
not
I
address
couldn't
this
believe
issue.
what I saw. Something has to
for different purposes.
There's an arbitral award. A second
With greatest respect, yes.
34 has been dismissed.
Yes.
The 37.
But Lord Lordship will see
And,
that neither of the forum below address this issue. And Lord, it is very fundamental. Lordship have already taken a view.
And
that
your
when there is
only contention is that because your payments from BSNL were held up, therefore you will not pay him. Therefore you are delayed. How is he concerned?
Lord, kindly see, with greatest respect.
The grievance of
What
the
I said
petitioner
was,
is that in a petition which was filed by the petitioner under Article 227 of the Constitution for expediting the hearing before the Debt Recovery Tribunal, the High Court has virtually
Lord,
concluded
may I only say this?
the issue on merits.
Lord, my
that would have
contention
arisen
was
before
not
the,
that my
DRT.
liabilities
So the
depended on
orders
payment.
which
Your
was set aside were
contention
not
really is
impugned.
that
Yes.
because
Were not questioned by the
the
respondent.
payment which is
you
due
notice
to
and
him
say is admitted by you,
By me.
therefore there is no dispute.
There is no dispute.
But what is it, brother, just Manoj Mishra just mentioned, the words used are breach. Now, breach is wide enough to comprehend even non-payment of an actionable claim.
It is
Now, the
like,
notification technical
or
of 3rd of November and 15th March, you said, look, I have admitted my liability towards him, and therefore there is no arbitrable dispute.
Yes.
Before the NGT.
May I only
But
answer?
here,
On
in the
this
same
point,
matter.
look, on this point,
May only
you are under 136.
Yes.
On this point,
Yes, my lord.
three forums are against you. We are in a situation where there's an admission of liability by you to him. You say, because I admitted my liability, therefore there is no dispute. Can this be?
My lord, may I only make two
Some
submissions?
issue
My lord,
notice.
may I
That
make
is
only two
also
submissions?
for
Same
justice.
interim
Lord,
order
may
may be
I make
granted, that is on
submissions?
phase.
One is,
And even on law,
notice
you cannot write because the word which is used is breach. Breach of an admitted liability will always also give rise to a dispute.
if we look at section 7 of the Arbitration Act, it says there has to be a dispute. I am saying I have to pay. And I have given much prior to commencement of arbitration, my lord, I have given a schedule.
We can't give you take such a narrow view which will defeat the purpose of the Arbitration Act.
And then, my lord, there is a contradiction also in the award itself.
Thank you.
May I just say, Malas, one thing for my
See,
satisfaction? Grateful.
Even
Sir,
single day
Lordship
they
has
cannot
already
operate
taken
the
a
mines
view on
because
this.
they have to
There is a
pay.
judgment which is not even adverted to by the honorable.
income. We are issuing notice on interim. Item 3.
An interim relief may be granted for.
We're just saying notice on interim relief. You have to hear the other side. That's all.
Lord, here the
Ms. Jaising, what is the interim relief that you are
Lord, here the
seeking?
question is, my lord, whether the state government, with regard to its sales tax,
Tell us, are you at
The operation of the letters of,
dated 7th June 2024?
yes, my lord, because
Then,
all.
no, just tell us, because for our order we need that. Notice here, because question is whether sales tax dues of the state government will rank over the ITC. Dates for the government.
yes,
And you're saying that
and
there
25/6.
you are relying on
Prayer
rainbow.
number A at page
Rainbow
69.
is up for consideration before a larger bench. Returnable in anyway, we'll 4 weeks. It's a question relating further orders. Issue the letters, the communications dated 27 June 2024. Thank you. Issued by the National Commission for the Protection of Child Rights. You're saying that 7 June and 25th June, right?
Yes.
Both by the
NCPCR.
phrase
Yes.
Bharatiya
Those 2 dates.
Samvidhan and what about the communications of 26 June of the
Please, 1 week, just 2 minutes to make my submissions.
No, sir.
Just 1 minute.
So obviously all consequent.
All consequential steps taken.
B,
Item
C,
5.
D, E give you the
Aisa kar
dates
lo.
of the letters.
Pending further orders, the letters, the communications dated 7 June 2024
One, that
and
the
25
consignment
June
book was
2024.
admittedly overloaded.
One, what you are saying that the for protection of child rights, A, you have said, and the judgment of the High Court communications per incurium, dated in view of their own judgment in 2024
Meghalaya.
Are you pressing of the Chief Secretary of the State of Uttar
That
Pradesh?
also because at page
And the
103,
communication
the Honorable
dated
High Court
10
by
July
coordinate bench has held
2024,
that the
issued
notification
by the
of
Secretary,
50 stations
Department
is
of
not confined
Education and Literacy, Ministry of
for charging
Education. The
termination.
total amount involved in this case?
Not 1 crore
And
56 lakh
28
odd, my
August
lord. And I also need to place on
2024,
record circulars
issued by
which
the
say that
Directorate of
50.
Elementary Education, Government of Tripura, shall not be acted upon.
I have a small request to make, my lord. Obviously, the directions dated 10/7/24. I have made only Uttar Pradesh and Tripura parties because they're the ones who have now issued circular. Your lordship will be pleased on my oral
High Court says that
application
after
allow me to
you
add
cannot
all
charge
states
punitive
because
charges
all
after
states are
unloading
going
of
to
the
use
oral request
So for
of
that purpose, I have
Indira
documents
Jaising,
to
then
show
Senior
that
Counsel,
the consignment
liberty
book was
granted to
overloaded.
impede
That
all
would go a long way
states stroke
to
duties.
charge overloading charges.
Notice
You
you
should not
can-
have
amend.
permitted to
Yes,
upload
keep
the
comment.
goods in the
So
first
let me
place.
do all
Why
Carried
did
out
you
within
permit
in
it?
the course
That
of the
was
week.
wrong,
And
my
then you
lord.
can
That's
say,
all, finish.
pending further
But
orders.
Lord,
the order
overloading
will be-
charges,
And you can
if
say
he has
liberty
booked.
5 and 30, therefore we'll have appearing on Thirty is the behalf same, of
Yes,
the
my lord.
state stroke duties and the central agency for the Union of India.
Deeply obliged.
My lords, the
Yes,
in item
Mankija,
41 is
the
a recognized
property, the
madrasa
hotel
matter.
premises are in Ahmedabad.
That's
Parties
immaterial.
are from Ahmedabad.
Listed
Only says, it says that
listed
the
today. The
the
recognized
place of
madrasa
arbitration
matters
shall
are
be New
also
Delhi.
listed
And they've
today.
appointed a
So
sole
That-
arbitration.
not
tribunal.
my-
That's
that's
immaterial, your
yeah, yeah.
lordship.
Medical
appearing in
seat
item
will be
four. Yeah, it's
Ahmedabad, actually.
It won't be, your lordships. That's completely immaterial. Once there's a party autonomy, once there is a clause of place of arbitration, after BGS and BBR, your lordships.
What difference does it make whether the
It makes a
arbitrator is
difference
appointed by the
because
Delhi
the
High Court
whole
or?
law, which was clarified in
My lords, 41, my lords, today is a recognized madrasa matter in
entered
which
into a
this is the
sublease
matter
for a
pertaining
hotel
to all
premises
recognized
situated in
madrasas.
Ahmedabad.
Lordships will kindly
Yes,
see
so
my
pleadings are complete
arbitration
in
clause
this.
Item
in the
11.
charge.
My lordships will hear that.
Lordships may kindly see this.
Consider,
This
in
is
the
a
case where
conflict
the
legal
funds are collected from the consumers,
14.3
invested by the
uses
state.
the word place.
Lord, I appear for
I'll
the
just explain to your lordships what the
Lord, this,
law
the
is, and
PDF rule itself says it
relegated
has
to a
to be
law
by
which
way
was
of
prior
investment
to
by equity.
BGS Soma.
Kindly,
Lordships may kindly take this
You
chart.
like to
This is
consider
the conflict of views,
then
and these are all the views which have been
Sorry?
held
An
and
early date
concurrently
return
held
will
and followed after BGS
pleading,
Soma
you file after
consistently.
Diwali. You file your counter, we'd like to
Say
hear you
about
for
clause
maybe half an hour, we'll hear you for
16.6.
15
I'll
minutes.
explain that because BGS
Deeply.
Soma
I was also
very
on the
clearly
interlocutory.
clarifies that
Sorry?
if there are
In the eye
two
also?
clauses.
Yes,
When
we'll
arising
hear them.
therefrom
We are not
shall
passing
be
any order, you
governed by
file
the
your
laws
counter.
of
Absolutely.
India
So that is
and
Item
shall
12.
be under the jurisdiction
This
of the
has to be
courts and
tagged, right?
amicable.
That is exactly what is explained by Justice Nariman in BGS Soma. He says that there are two clauses, two sections. One is section 20, subsection 3, and there is a section 2, which defines courts. These are for two separate purposes. As far as venue and seat is concerned,
Just do this.
it
Can you
is
come in the
connected
morning
to
tomorrow
party
or just
autonomy.
at 1 o'clock?
And the
I'll-
arbitration and challenges
take it
to
as a
arbitration,
mentioning
the
and
appointment
it's
of
only the
arbitrator
appearance.
will all be relatable to the place which is equivalent to the seat. Now, this is the view which has prevailed now, and prior to this
What
view
is the clarification
was that
that
if
you
there
have
are
to
two
issue notice?
jurisdictions, that was the bulk of view,
Mr. Raghav.
that if there are two jurisdictions, then either can be invoked. This honorable court has said.
Mr. Navneet will accept notice on behalf of.
No, it cannot, your lordships.
I'll hand it over in writing.
Would your lordships give me 2 minutes?
condoning delay
Lordships will see what lordships have held.
We have to always make, business sense out of any concept.
Business sense only, your
54
lordships.
days, 57 days.
Business
I think.
sense only.
It's based in Ahmedabad.
Right.
And third, clause
My
16.6
lords,
specifically
it's for
refers
hybrid
to
court of
Distinct
hearing
clause.
by
It's
the
not the
family courts to
arbitration.
get
And
over
let
the
me just
financial
show to
and
your
non-
lordships.
governed by the
Lordships,
by the
this will
provisions of
create
the
havoc,
state
and if
courts.
your lordships will
The
just
family courts
give
are
me
not
the indulgence
standalone
of
courts.
taking this chart.
My lord,
Consist-
they have been appointed by
to the
they are
former
appointed
district
by
judge.
the
Your
state
lordships,
government,
that's
my lord.
besides the point. The
They are
point is
appointed
this,
under
that
by
I
the
am
state government
I am a
under
national.
the Family Courts
I
Act
don't want to
19,
delay. Your lordships will
1984.
appoint an arbitrator
Therefore,
today. I
they
will go to the
act
arbitrator. I do
independently.
not have a
And
quarrel with application,
it is not, they don't
appointment.
come
In
under
fact,
the
I
High
want
Court
an
that way.
arbitration. I have consented.
Notice, Mr. You are not saying that arbitrator is
Oblige, my
biased.
lord. My lord, returnable.
An exercise of jurisdiction, which
Item
is
14.
contrary to the law itself goes to, lordships will give me 2 seconds.
Without even
Lordships,
noticing the relevant regulations.
lordships will just look at
Relying on some
para 82.
regulation which has general application, but
Lordships will
there is
kindly
a
see.
special
Then because the
regulation,
point
page
of law is made, we don't
356.
issue
It's
notice.
not a
In
question
regard
of
to
law.
DBC,
I'll
Can
tell
you
you.
just sort of explain to us maybe in a,
Just give
in
me a minute,
nutshell,
your
what is
lordships.
the
The
issue
reason
really?
why I'm
Because,
pressing is
I
for a
was also
particular
wondering
reason,
how in a review
not to
petition
concern
they
with my
resolve.
parties.
appreciation
Item 7,
has to
yes.
be allowed anyway.
Right.
And there is a sinking fund
The
in
lordships
regard
will
to
then
DBC
clarify.
because of the
Item 7 to issue
historical
notice on delay and tag it with that other matter.
Your lordships, may I
That is the
just
bonds which
clarify,
are issued by
seek
DBC.
clarification, because now,
From item 8 to time are redeemed from the sinking fund, which is created under section 40.
factually incorrect as found by the original judgment. But in the review, without even any consideration, it's allowed. And please similar the relevant regulation.
The sinking fund is not created by you from the tariff realized from the consumers?
No.
How is the sinking fund created then?
356.
Because at page 24, on the other side, tribunal holds that since it is created under section 40 from the tariff which is realized in the Bombay High Court, we had a very distinguished capital asset created through such bond amount does not qualify for depreciation.
You went only for an order for expediting the hearing before the DRT.
Aspect is considered and said
Court
that
in
these
your
are not the
petitions
funds which are
exercise the
used
orders in your
for
favor
the
which were
purpose
never
of creating the
questioned.
capital asset.
2018.
Yeah. And
I read your petition twice over because
Just
I
make
couldn't
us
believe what I
understand
saw.
33 and
I said
34
maybe I've read
of
it
this
wrong.
impugned order.
So I
Just
read
make
it
us
a second
understand.
time.
Yeah.
Because it was
Now, please see first.
issue notice here.
First,
Yeah.
and just make us
That's the
understand
income
what is
satisfied
the
order and send it back.
Let the reasoning of the tribunal is in the
Stay the
review
order, by the way.
petition.
Still stay the order. Impugned order.
The earlier judgment of the Supreme Court did not go into the duplication.
It says It cannot be gainsaid that redemption of bonds from contribution to sinking fund is a special tariff element provided to DVC under Section 40 of the DVC Act. Something to do with interpretation of this provision. In addition to the tariff elements provided in the tariff regulations issued by the Central Commission from time to time, there is nothing in the above noted judgments of this tribunal and of the Supreme Court that depreciation shall be allowed on the capital assets created by utilizing the bond amounts. What is it trying to convey?
Now, the notifications
question
of
is
3rd of
raised in the
November and
earlier
15th
round
March
at page,
are in question before the
kindly
NGT,
have a
the
look
High
at
Court is
page
recorded.
155, 156,
question
para
before the
25 of the
NGT.
tribunal.
What the
Here,
tribunal
in the
seems to
same
be saying
matter-
is that a distinction needs to be created between depreciable assets
That
created
is-
by the use of the bond
Correct.
fund
Yes.
and depreciable assets created by the use of funds from other sources.
Correct.
If you accept that,
Yeah.
Can I just add, Lord Lordship, permit me?
issue notice.
Happened,
Yeah.
Lord, when this
The same
DVC
initial
was
order may be
initially
granted, that is
set
on
up,
phase.
the government didn't want
It's a
to
notice on
fund
interim
it on
relief
from
served
its own
them
money.
only. Right.
So the government decided that there'll be a sinking fund for the original capital asset, not depreciation comes much later. Your
For the
Lordship
new-
knows. So the original capital asset was set up on the basis of which fund, and Section 40 of the DVC Act said that this fund will be, the servicing of this fund will be by the tariff. So that was the original asset when it was created. Depreciation under the regulation, your Lordship knows, is for the use of the asset and its replacement value whenever
Even
it will happen,
single day
maybe
they cannot
15 or
operate
20
the
years
mines,
later.
because they
So
have-
depreciation has been separately
Serve them
provided
just
for
the
by the Act,
invasion
again by
notice
the
on
Act,
interim
DVC
Interim
Act
relief may
itself.
be granted for-
So
Just saying
sinking
notice on
fund, the
interim relief,
original
you have to
creation
hear
of
the
the
other
asset,
side, that's all.
and depreciation for the replacement value of the asset whenever it will have to be replaced. That is,
Mr.
replacement
Ms.
is not
Jaising,
done by the fund.
what is the interim relief that
Replacement
you
is
are
done on
seeking?
the basis of the depreciation only.
And
Replacement has not even happened
there on
today.
the record.
Replacement
Tell
will
us
happen
you-
at some
are you
stage
at
because
the-
these are all funds blood which was taken
Operation of
between
the
70.
And the
debtors
tribunal
of
now in review
June
holds that you will not be entitled to
2024.
depreciation
Yes,
on
sir.
the, on the
No,
sinking
just
fund,
correct,
because
on
for
the
our
sinking
order,
fund.
because originally when it was created, it was out of the tariff.
7 June
But
of the
this-
And
NCPCR.
kindly see the
Acted upon.
relevant regulation.
They're being acted upon.
Give us the
What do you
dates,
say?
dates
for
for
our
the
order.
This court,
It is
this
7,
issue
6
actually
and
came right up to
25/6.
here. 2007,
Number
Lord Justice
A
Anil
at
Dev
page
Singh, when he was
69.
sitting Lord in the
Issue
appellate
notice,
tribunal, said that they are entitled to
returnable
both
in
the
4
sinking
weeks.
fund also as well as the
Pending further
depreciation.
orders.
One private party
letters,
came
the
here
communications
and Justice
dated
Gogoi's judgment in
7 June
18 said that yes,
2024,
these are
Appel.
both
issued by the
statutory
National Commission for the Protection of
entitlements of the
Child Rights.
DVC